Oh, it says Christopher Driscoll.
What about now? Okay. All right.
Mr. George, you want to turn your camera and microphone on?
Yes, Your Honor. Can you hear me, Judge?
I can, we can't see you.
Oh,
There's a little thing that looks like a camera on there. I can have
there you go. Can you see?
Mr. Hunley show you how to use it.
I'll go get it. Good.
Can you see?
Yeah, good to do that. We'll consult with every attorney that's over 75 and maybe it won't last long. There you are, Mr. George. Thank you for addressing.
Judge.
You look like you're running for United States Senate in Pennsylvania there. I didn't know. Okay, this is Commonwealth of Kentucky versus Jeffrey Feast. Your client, Mr. Feast, is present for sentencing. This case had a pretrial diversion, which was voided on July the 28th, 2022. Okay, what is the Mr. Feast, you want to stand over this way, Counselor? What is the Commonwealth's position on sentencing in this case?
The Commonwealth's recommendation for the original plea agreement was upon if pre-conversion was avoided, Commonwealth is recommending 2 years.
Okay, so 2 years to serve. Okay. What do you have to say, Mr. George?
Judge, I thought our conversation was he would be probated.
Whose conversation?
Barbara, did we discuss probation? I'm pretty sure of it.
Well, we probated 3 years.
I'm very confident of that, but Your Honor, considering particularly his condition now, which I sent you an update, they found another lump in him
Well, now, wait.
in a private area next to a tube, and he. But anyway, we did a diversion. We agreed, which would be what was
You're
in the
breaking up,
pretrial
Mr.
diversion. And all right, let me see.
George, Mr. George, you're breaking up. I can't hear
Yes, sir.
you.
Can you hear him better now, Judge?
Well,
hear me
yeah, I
better?
can for a few words.
Let me go outside, Judge. Hang on.
You're fine. You're fine where you are right
Okay.
now. If you just stand still, that's the problem.
All right.
Okay. So the Commonwealth is, I mean, I don't have any medical evidence in front of me here. Has the Commonwealth been provided with any medical evidence or anything?
I have received email stating that there is an appointment. I think this morning, I thought there was an appointment for treatment. But as far as documentary evidence, discussion was, as I recall, that the Commonwealth did not object to this sentence running concurrent with whatever occurs in a dare.
This is a dare.
There's a new case.
There's a new case.
That is twice.
What is that case?
Felon in possession
Of a handgun? And
Judge.
well, yes.
If the court recalls, evidence was given to you early on that he had a gun, but he had actually been out hunting that day. And he was arrested. And later we had filed a motion and there was an agreed order entered that he'd get home incarceration because of his cancer situation. And I had provided the Commonwealth, the Attorney General, Ms. Whaley, evidence of his cancer issues, of which he's been going to Nashville for chemo for several months now. In addition, I had furnished Judge Murphy and Brian Wright documentation of his cancerous condition. Our discussion when we agreed to this was that the diversion would be void, that he would receive probation. And I had asked Miss Whaley if she could talk to Brian Wright about the case, see if I can get him probated there, because this is his first conviction, the one that you had before you. On the date in question, he had been hunting, and wasn't that he was out.
Okay, you're talking about this, you're talking about the possession of firearm, new charge is what you're talking about. Is that correct, Mr. George?
Yes, sir. That's why you had.
Well, here's the problem. Here's
All
the problem I have here. I'm, Mr. Feast was revoked. Yeah. There is a letter in the precinct's investigation report from Vanderbilt University dated September 13th, 2022. You have that letter. So Mr. Feast is a patient, and I won't say what, for his privacy purposes, I won't say he will need lifelong treatment. He'll have chemotherapy every 2 weeks. Have you talked to Brian Wright to see what they're going to do on that case up there? Mr. George, you represent him in that case?
Yes, Your Honor.
I don't have very
Judge?
much. I don't have very much medical information here.
Well, I was going to ask you. If you
Wait,
want
wait
us
just
to-
a wait just a second, Mr. George.
Yes, sir.
I don't have very much medical information here. Considering what this letter says and the sort of treatments are involved, and there's chemotherapy involved, and he's going to continuously on that. I just say to the Attorney General's office that putting somebody in the Adair County Jail could be a death sentence. Okay. I just know that chemotherapy takes down people's immune systems sometimes, and they do the best they can with an ancient facility. But I've been in every nook and corner of the Adair County Jail, and under the best circumstances, they got problems there. So, what does Department of Corrections, as far as in-home incarceration, how does Department of Corrections handle that? If I were to,
You can place that monitor on.
yeah.
And then I would monitor.
Well, I'm going to sentence you to 2 years. That's what the agreement was. And at your cost, is your client willing to assume the cost of in-home incarceration, Mr. George?
Yes, Your Honor.
Okay, I'm going to in-home incarcerate. Yeah, I'm going to put you on a curfew. You can go to church, and the doctor, or to visit your lawyer's office. Okay, that would be the conditions. If anything other than that, you can give him some leeway if you had to do something about that. And then when we see what happens in the Adair Circuit Court case, we'll take a look. The problem that I have is we tried, Mr. Fish, you were given a big break on this pretrial diversion and you bombed on it and having a weapon involved in it. There are two things that bother me the most about people that are on pretrial diversions or on probation. And that's driving under the influence or having a weapon. Those are the two worst things that bother me. So, how long? Who does your ankle bracelets in home incarceration?
We do it, Your Honor. I don't know the exact company, Veritrax, we use, but
Yeah.
we monitor, put them on, so
Okay, when can you do that with him?
how long does it take me to acquire one of the monitors, Bowling Green, so.
Okay, well,
I'd say probably-
I'm gonna enter the judgment. You had an opportunity to look at the pre-sentence investigation report done by probation and parole, sir. Is it substantially correct? Okay, Mr. Judd Mr. George, is there any reason why this gentleman should not be sentenced?
No, sir.
Okay, I'm gonna sentence you to 2 years. However, because of your medical condition, I'm gonna make it an in-home incarceration sort of deal that's monitored with the restrictions that I've told you, and you're to bear the cost of market. Where the court cost, we don't know what the court costs involved. Probably previously paid the court costs, but I'll hold in reserve the court costs and when I check the clerk's office. If there's anything else you have. Okay, you shall have this monitor on you when you leave here today. You can go home. I don't want you outside of your home until they come and put the monitor on. You want to go to his house and put the monitor on, or do you want him to
He
come?
comes to our office, and put it on.
When you want him at your office?
Maybe we get that probably put it on there.
Okay, you be at 10 a.m. to the Department of Corrections Probation Pro Office in Columbia at 10 a.m. Between now and then, you'll be under a curfew, not to be outside of your house, not to have any firearms, not commit any other felony. Okay. Okay. Thank you very much, Mr.
Thank you,
George. You have
Judge.
anything else?
That's all for the morning. Thanks,
Okay,
Judge.
Thank
Thanks,
you
Barbara.
very much. Okay. Okay. Okay, Louis Arms. Yes, we are. Okay.
I'm having to call the jail and I emailed the order 2 days ago and they said it.
What jail is he at?
Leave just.
Who got who was supposed to transport? He's a state prison.
They transported him last time.
Express my displeasure.
Well, I would call them early and I've got something I can send them that'll express more than displeasure. Wait a second. What do you got?
I've got a real important juvenile court case that we moved to 17 next month on that.
Well, y'all just send me an agreed order on when you want to do it. We'll transport and get it in here. Okay. Louis Arms. Louis Arms. You what? Yeah, well, it's just a motion to forfeit. That's all it is. You have any objection to the forfeit? Will they submit the order on forfeiture? Bronny Bates. Bronny Bates, Commonwealth versus Bronny Bates, 22 CR 0026. Are you Bronny Bates? Born in 1984. Last four digits, Social Security number 5442. There's been no agreement reached on this.
No, Your Honor, we're doing additional discovery. Okay.
Okay. How many days does it take to try this case, Mr. Stuck? Okay. Why do we want to wait till next year?
I've got it's here when I do my medical, I need to get Dr. Rice.
Okay, could you be ready sometime in December, you think?
Set a trial next month.
Well, let's come back. Let's come back next month and see if we can set a December trial date if you can get the medical records. Okay. You be back here on November 17th. Michaela Beatty. Commonwealth versus Michaela Beatty, 21 CR 00128, and the companion case of Tyler Beatty. You represent him too?
Yeah.
Tyler Beatty.
We have.
Wait a second. I gotta set them up here. Okay. Yeah, are you Michaela Beatty? Year of birth 1999. Last four digits, social security number 7372.
Yes.
And you are Tyler Beatty. You were born in 1997. The last four digits, social security number 656350. I understand that you all wish to enter a plea today. Is that correct? Is there any objection for me to go over the documents together? They've signed waiver of dual representation.
Yes.
These are felony pleas, is that correct? Okay. Okay. Well, I better do them separately. Okay. No, just wait a second. Michaela Beatty, I understand you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given? Are you the same person named in indictment number 21 CR 00128? Is your judgment impaired today in any way? Have you had plenty of time to discuss this matter with your attorney? And are you fully informed about your case? Are you satisfied with his advice? You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. Right to speed trial, the jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, the right to appeal this matter to a higher court if you lose, and the right to require the Commonwealth to prove under reasonable doubt that you are guilty. By entering a guilty plea today, you waive those rights, and I may consider the Commonwealth's recommendation that I may apply any range of sentence provided by law. In the event that I do not accept the Commonwealth's recommendation, I will inform you of such, and you'll have a right to withdraw your plea. Prior to entering a judgment in this case, I will have a pre-sentence investigation report done by probation and parole, which you'll have an opportunity to review with your attorney before sentencing. If y'all all move to the left here just a bit. What is the Commonwealth's recommendation in this case?
The proposed plea in this case is Ms. Lady will plead to the immediate charge of assault second degree under extreme emotional disturbance that would make this a class B felony. She would have a sentence of 5 years, serve 90 days in custody, an additional 90 days home incarceration, the balance probated for 5 years. Then the court, she would have court cost discretion, court, maintain
Is that what you agreed to, ma'am? Come back up here.
Yes, sir.
Has anyone threatened or coerced you, or are you entering this guilty plea because you did the actions in the indictment or the indictment as amended? You did the acts that you're accused of, or as amended, it's amended in the amended indictment. Is that correct? Okay. Now, you understand by entering a guilty plea today, any future convictions of felonies could have an enhanced penalty under persistent felony offender law. Do you understand that? Okay, is that your signature on the document? Okay. I'll accept the plea, order pre-sentence. How many days does she have in? How many days do you have in? You were incarcerated for a while, weren't you? You were incarcerated. Okay. Okay. Mr. Bailiff, pick that up on her. Okay, give it to the clerk here. Okay, okay, you're in the custody of the jailer.
Your Honor, ma'am. We have.
What are you talking about?
She didn't. Okay, I don't ever do that, but she's got how many minor children? How many children do you have? 2. And where are they? Are they with you now or somebody? Yeah. Do you have custody of them? Or do they live with you?
No.
Okay. So what does she have to prepare? Well, she can talk to them after school today and explain what's going on. She can turn herself into the Dare County Jail by 6 o'clock tonight, okay? Tonight, yeah. That gives her opportunity to talk to them. I think it's not humane not to allow her to talk to children, explain where she's going to be going. Mr. Baden, you want to come up? I understand you've also filed a motion to enter plea today. Is that correct? Are you currently under the influence of drugs or alcohol?
No,
This is plea freely and voluntarily given. You previously identified your date of birth and your social security number. Is your judgment impaired today in any way today? Okay, have you had plenty of time to discuss this matter with your attorney? Are you satisfied with his advice? And you reviewed the evidence the Commonwealth has against you. You believe you're fully informed about your case. You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept your plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. You have a right to speak trial by jury, right to be represented by counsel, right to be confronted, cross-examine all witnesses, call, testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and right to acquire the Commonwealth prove on a reasonable doubt that the guilty charge against you. You understand that entering a guilty plea, you can give up all those rights. Now, I may consider the Commonwealth's recommendation, but I may apply a range of sentence that is allowed by law. If I do not accept the recommendations, I order a pre-sentence investigation report and would be inclined to impose a harsher sentence. But if I do that, you have a right to withdraw this plea. Okay, have you previously been diverted in the last 5 years? Have you had any felony convictions in the last 10 years? Okay, are you on probation now out in court? Do you understand that if you complete the diversion program, the case will be dismissed, pre-trial diverted? But if you do not complete the diversion, you'll be brought back in front of the court. If I revoke the diversion at that time, we'll schedule a sentencing hearing. You'll be a convicted felon. You understand that? Would y'all move to the left here? Mr. Stockton, who's going to present the Commonwealth's recommendation?
This is the same plea charging him himself in the extreme motion. 5 years sentence, pre-trial verdict, 5 years probate. Court costs discretion of court.
Okay, what are the court costs in each one of these?
$210.
$210, and I'll allow you to pay yours $30 a month, starting 30 days from today. And ma'am, you can start paying yours at $30 a month, 30 days after you're released. Okay, they'll give you some time to get out and get employment or whatever. You'll need to meet with probation and parole over here.
so they can go over the pretrial diversions sort of things. Both of you will. She'll be incarcerated in Adair County, so you can meet with her up there. Is that correct?
Yes, Your Honor.
So, Mr. Beatty, if you'll make arrangements to meet for the interview there. We'll schedule Ms. Beatty's sentencing on November the 17th. Okay? Okay. Thank you very much. Jason Bowers. Commonwealth versus Jason Bowers, 22 CR 0082. You're here for the purpose of arraignment. Mr. Bowers, you have an attorney.
Yes, sir.
Okay, I'll continue that appointment. You have the right to remain silent. You're represented by counsel. Anything you say could be used against you. So I suggest that you do remain silent. Okay. If you have any questions, you can step away from the podium and ask your attorney. The grand jury of Cumberland County has returned an indictment charging you with wanton endangerment in the first degree and discharging firearms or other devices across a public road and disorderly conduct in the second degree. Mr. Bailiff. Counselor, you acknowledge the identity of your client received indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pre-trial motions.
Yes, Your Honor.
And we'll set, what's the negotiation day this coming month? November the 4th at 1 p.m. here in Cumberland County. You be here, that's part of your bond, and your next court appearance is November the 17th at 9 a.m. Both of those are conditions. You go here and negotiate, see if you can reach an agreement with the Commonwealth. If you can, you'll be here for enter a plea or set a trial date on November 17th. Okay? Thank you very much. Donnie Branham. Commonwealth versus Donnie Branham.
Your Honor, we just got paperwork on Mr. Brandon with all the resolution policy that I'm not going to have to go over.
Okay, if you want to take him back there. Billy Fairley. Mr. Branham, they got paperwork to go over with you if you'll go with your attorney there, okay? Billy Fairley. Do you prefer Fairley or Farley? Fairley, okay. Billy Fairley, we're here on a pretrial conference. Are you born in 1974, sir? Okay, last four digits of your social security number, 4246. Okay, this is 22 CR 0075. What do you have?
We have an agreement, Your Honor, for felon probation.
A felony plea? Okay. A motion has been tendered, sir, that says that you wish to enter a plea today. Is that correct? Are you currently under the influence of drugs or alcohol? Okay, is this plea freely and voluntarily given? Are you the same person that's named in indictment number 22 CR 0075? You have plenty of time to discuss this matter with your attorney. Are you satisfied with her advice? Have you reviewed the evidence that the Commonwealth has against you and you believe you are fully informed about your case? You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Your right to speed trial by jury, right to be represented by counsel at the jury trial, the right to confront and cross-examine all witnesses called against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to a higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty of the charges against you. Understand that by entering a plea today, you give up all those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept any recommendation. Prior to accepting any recommendation, I will await the pre-sentence investigation report from probation and parole. In the event that I do not accept the Commonwealth's recommendation, after reviewing that and decide to impose a harsher sentence, you'll have the right to withdraw your plea. You understand that? Y'all step to your left here, and who's going to present the Commonwealth's recommendation? Mr. Stockton?
No, Mr. Farley agrees to put together the flagrant non-support of citizens for 5 years. They make monthly payments of $500 a month to be paid in child support. The enforcement division. First payment's been paid on December the first, the first day thereafter, each month's paid. He currently owes a total balance of $31,683. That is as of October 14th. He agrees that probation shall be extended until this is paid in full. He'll pay court costs at discretion of the court, maintain and perform.
Is that what you agreed to, sir? Okay. Are you pleading guilty because you are guilty of the acts charged in the indictment as amended? Knowing your constitutional rights, is it still your desire to give up those rights, enter guilty plea, and allow the court to fix your punishment? You understand that after a guilty plea like this, any future convictions of felonies could be enhanced as far as the range of penalties by law, under law. You understand that? Is that your signature on the document? Okay, now the Mr. Stockton, that was recommended that this be probated, is that correct? So I will not take you into custody today because of the recommendation. And I will need for you to schedule a meeting with probation and parole. When can he come?
You can meet with me here now. I'll sit downstairs.
Okay, just go over there and meet with him. You'll be back here for sentencing on November the 17th. Okay. Okay, thank you very much.
Here's what we're doing.
Richard Hawkins. Richard Hawkins. Commonwealth versus Richard Hawkins, 22 CR 0024. Are you Richard Hawkins? Born in 1987, last 40 digits, social security number 3452. We're here today for the purpose of sentencing. And you had an opportunity to look at the pre-sentence investigation report done on probation and parole. Is it substantially correct? Counselor, is there any reason this gentleman should not be sentenced?
No, Your Honor.
Upon a plea of guilty possession of controlled substance, first degree meth, the defendant shall receive a sentence of 3 years, serve 60 days, balance probated for 5 years. He shall receive credit for time served, probation to be supervised upon plea of guilty of failure to maintain insurance. He shall pay a fine of $500. What's the court cost?
Court cost will be $220.
Okay, so I'll merge your court costs and the two of them, it's the total will be $720, is that right? I'll save you $220 by merging the court costs in those two cases. So you will, does he have any days in yet?
65.
So he has his days in already?
I have looked around.
Okay. You go over there and meet with probation and parole, and they'll set you up on for your supervision. And if it comes out that you're short of 60 days here, stay here in the courthouse and we'll take care of that. Okay.
Your Honor, how much should be paid for the $45?
Can you afford $40 a month? You can pay it all off if you want to. But it wasn't $500, it was $700.
It was $500 fine and then $220 court costs and then you merge court costs.
Yeah, so it's $720.
I'm sorry, Your Honor, I thought you guys merged it.
The 500 is not cost.
Right, so it's kilo.
Fine. No, he owes 500 plus the cost. There were two different charges. I merged the costs of two of them, give him one court cost. It's $720, correct?
If your court costs.
$720, okay. Okay, Richard Hubert. Arraignment. Commonwealth versus Richard Hubert, 22 CR 0070. Are you Richard Hubert?
Yes.
Born in 1953. Last four digits, social security number 6345. This is case number 22CR00070. You're here for the purpose of arraignment. You're represented by counsel. You have the right to remain silent. If you have any questions about what's going on, step away from the podium and ask your attorney quietly. Okay, the grand jury of Cumberland County has returned an indictment charging you with possession of a controlled substance in first degree and possession of controlled substance not in the original container. Counselor, you acknowledge the identity of your client, receive the indictment, wait formal reading and arraignment, enter plea not guilty, serving all pre-trial motions.
Yes, ma'am.
You need to be here on November the 4th at 1 p.m. for negotiations, and November the 17th for your next court date. Both of those are conditions of your bond. Okay. Okay, thank you very much. I'll be signing a reciprocal discovery order and be getting evidence. James Hurst. Commonwealth of Kentucky versus James Hurst, 22CR0013, 22CR0038. Are you James Hurst?
Yes, sir.
Born in 1970. Last four digits, social security number 2119. You're represented by counsel today. If you had an opportunity, Mr. Hurst, to read the recent investigation report, is it substantially correct? Counselor, is there any reason this gentleman should not be sentenced today?
No, yeah.
Okay. Upon plea of guilty, of trafficking and controlled substance first degree greater than 2 grams, she shall receive a sentence of 5 years. On plea of guilty of weapon lawful taking over $1,000, then she'll receive 5 years. The two sentences are to run concurrently for a total 5 years, probated 5 years, supervised. The defendant agrees to pay $3,500 to the victim Rimmel, the rate $100 per month to Cumberland Circuit Court. First payment to be made 30 days from the entry of a plea. Has that payment been made? Okay, what are the court costs?
It's, on one case, they're $80 plus you merch the cost. $80.
It's total $300 court costs. I'll allow you to pay that at $30 a month extra, so you'll pay $100 toward the restitution, $30 for the court costs. The first court cost payment will be 30 days from today. Yeah, I'd like you to make the first restitution payment today. Okay. Okay, you'll need to meet with the probation and parole officer who's over there, and he'll give you the conditions of your supervision, okay?
If there was one additional question.
Okay. Was a what? Vehicle, yeah.
I don't even know the situation. Again, that was a question.
Well, so he alleges that he had bought the vehicle.
Yeah, the victim claimed that they didn't sell it, they stunk. They didn't think it's one of those right. Does that big package there?
So, no. My understanding is, Mr. Hurst doesn't want to continue with the plea. So you'll be. Probation for it. So is that all?
Yeah, that's it.
Thank you.
Dustin Sutherland, was there an active warrant out on that? Did you? Mr. Stockton? There's an active warrant out on Dustin Sutherland.
Yes, he was here once before, I believe, in fact, I will come back to probation. Because this motion of vote originates from another charge. So I'll fight,
Okay. And we'll pass over it. Since there is an active warrant out, he shall be here on November 17th. Change the date on him. Dylan Weaver. Cromwell versus Dylan Weaver. Are you Dylan Weaver? Okay, this is 22 CR 0065. You're represented by counsel. Mr. Weaver, were you born in 2000? Okay, the last four digits, social security number 5750. Okay, we're here for pretrial conference.
You know, this case involves 5 different defendants. Mr. Burton, William Burton, dental work, both employees. I think Ms. Weaver will be able to do another pre-trial conference on her. And if those 3 under please, I'm going to dismiss Mr. Weaver from this job. So I just like to see this moment.
Continue this to November 17th. In the same bond, okay? Tammy Weaver. Cromwell versus Tammy Weaver. 22 CR 0073. Commonwealth of Kentucky versus Tammy Weaver. Are you Tammy Weaver? Born in 1978. Last four digits, social security number 6306. Represented by counsel here. What's the story here?
We have had discussions with folks in this, we have no report.
Will you be here for negotiations on November 4th and your next court date is November 17th? Okay. Trey Wright. Commonwealth versus Trey Wright. 22 CR 0076. Are you Trey Wright? You born in 2002. Last four digits, social security number 9817. Okay, you're here today for a pretrial conference. What does the Commonwealth have to say about this? Mr. Wright, a motion has been tendered that says you wish to enter a plea today. Is that correct? Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given? Are you the same person named in indictment number 22 CR 0076? Is your judgment impaired today in any way? Is your judgment impaired? Do you know what's going on? Okay. Have you discussed these charges with your attorney and are you satisfied with her advice? Have you reviewed the evidence the Commonwealth has against you? And are you fully informed about the case? You do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, the right to require a Commonwealth prove beyond a reasonable doubt that you're guilty of charge against you. Understand that by entering a guilty plea today, you give up all of those rights. And I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept the recommendation. In the event that I do not accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. Have you previously been diverted in the last 5 years? Do you have any felonies in the past 10 years? Are you currently on probation? You understand that if you fully complete the diversion program, the charges will be dismissed, pre-trial diverted, and you can have them expunged off your record. You understand that? You understand that if you do not fully complete the diversion, you will be brought back before the court. The court will schedule a sentencing hearing. You understand that? Step to your left, please. Counselor, what is the recommendation of the Commonwealth?
Upon pleading guilty to that finding, section 1, then agrees to pay restitution amount of $3,950 with interest free or payable in Cumberland Circuit Court, $300 being each of the payment in the amount of $100 shall be due in the same of each month thereafter. The rest of you should be paid permanently for the court clerk and the 75% fee. The defendant shall pay court costs and discretion of court. The remain for employment and 90 hours early community services you may be willing to retained. Then it shall remain on the division of the law Massachusetts for costs.
Is that what you agreed to, young man? Are you pleading guilty because you did commit the acts as charged or as amended in the indictment? Pleading guilty of your own free will. Okay, you know your constitutional rights. Is it still your desire to proceed with the plea and allow the court to fix your punishment? Is that your signature on the document, the restitution agreement? I accept the agreement, sign the conversion order. You will, however, will need to meet with probation and parole officer over there. Okay. Court costs, what's the matter, court costs?
$210.
You can play it $30 a month, start 30 days a day. Okay. Okay, now we had one case we need to go back to Mr. Donnie Branham. Are you ready on that?
Cumberland County.
Commonwealth versus Donnie Branham, 18 CR 0069 and 22 CR 0078. Y'all have a plea agreement in this case?
Yes, Your Honor, we have.
Okay, a motion's been tendered, Mr. Branham, that says you wish to enter guilty plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No, Your Honor.
Is this plea freely and voluntarily given?
Yes.
Are you the same person named in indictments number 18 CR 0069 and 22 CR 0078?
Yes.
Is your judgment impaired today in any way? Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you? Do you believe you're fully informed about your case? You understand that you do not have to enter a guilty plea today. You have certain rights under the United States and Kentucky Constitution. Before I can accept your plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speak trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses to call testify against you, right to produce evidence, the right to call witness in your favor, have to process issue, compel attendance, the right to appeal this matter, hire authority to lose, and the right to require a Commonwealth prove on a reasonable doubt. But you go through the judge, you understand that in guilty plea today, you give up all those rights. You understand that? Now, may consider the Commonwealth's recommendation under the plain range of sentence provided by law. You do not have to accept the recommendation. Prior to accepting the recommendation, always pre-sentence investigation report done by probation and parole. In the event that I not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. You understand that? Y'all step to your left here. Mr. Stockton, what is the Commonwealth's recommendation?
Case number 22-78, the Commonwealth recommends since 30 years in probation, total substance first degree, 90 days jail, balance, probation, 5 years supervised, and the DUI third offense, the limit paperwork was one. It was one mission in this. So you would pay a $500 fine cost and do 30 days in jail, that would make the term for 90 days, for total 90 days. Then he also has pending Cumberland indictment number 18 CR 69, had a 5-year sentence. Commonwealth will file a motion to revoke probation. Mr. Branham, good for several years, done well. So I'm asking in lieu of revocation, once the 90 days is complete, you have one. Sure, I'll read all of that.
Is that what you agreed to, Mr. Brown?
Yes, sir.
Are you pleading guilty of acts because you did the acts that you charged in the indictment as amended?
Yes.
You do this your own free will. You understand that the range of punishment in future convictions on a DUI or another felony could be enhanced as far as the range of penalty because of these pleas. You understand that?
Yes.
Is that your signature on all the documents there?
Yes.
And what's the total on this?
$1,120.
$1,120. And I will allow you to pay that $100 a month, 30 days after you are released from jail. Start 30 days after release. You're in the custody of jail. Thank you very much. Okay, is there anyone else here on the criminal docket before we go to Zoom? Is there anyone else live here? Mr. Stockton, do you have anybody else live on here?
I'm aware of it.
Okay. Okay, we're gonna go on Zoom here in about 1 minute here. So Boyle County, it looks like you're on there. You just have one person. We'll go to Boyle County first. The Commonwealth Attorney is going back and get on the computer. Just take a second. I would ask you to prepare to bring Timothy Ray in Boyle County, if you could.
He's in here and waiting, sir.
Okay, thank you so much.
You're welcome.
Wayne County, would you turn your camera off and I'll get to you next, okay? Thank you. Okay, Mr. Stockton, will you turn your camera on, please?
Yes,
This
sir.
is Commonwealth Kentucky versus Timothy Ray, 21 CR 00141. Are you Timothy Ray?
Yes, sir.
Your year of birth is 1999.
Yes, sir.
Last 4 digits of your social security number 3132.
Yes, sir.
Okay, this says a motion for shock probation. Counselor, did you file this?
I did, Your Honor.
Okay,
We
you may
would
proceed.
ask the court, okay, we would ask the court to consider shock probation for Mr. Timothy Ray. Your Honor, attached to the motion that I sent out were letters of support from his family. Mr. Ray would have that substantial support. They would help him meet all the obligations he would need to meet with probation and parole. He has served 155 days as of September 30th, when I filed this motion, Your Honor, since his sentencing date. I believe that he could be compliant with probation and parole and any orders this court would set for him, and just wants to move forward positively, Your Honor.
What was the, Mr. Stockton, what ultimately was the charge that,
He had a theft, Your Honor. It was Robert Sproul's pickup truck. The truck was never recovered. The Commonwealth will oppose probation based on that fact because it was an expensive truck. If Mr. Ray could recover the truck, I might look at this differently. He also has a 5-year sentence in Adair County that's run consecutive involving another theft of a vehicle. So the Commonwealth's opposed to shock probation.
okay. Well, theft's a tremendous problem, and if you have a sentence consecutive and you've run this thief and spree, I'll just let the parole board deal with this when it comes time. So I'm going to respectfully deny the motion for shock probation. Boyle County, thank you very much for your cooperation.
Thank you, sir.
Yeah, let's go to Wayne County. They just have one person. Saw their camera on previously. Commonwealth Kentucky versus James Abbott, 20 CR 0063. Are you James Abbott? Mr. Abbott, were you born in 1982? Last 4 digits. Somebody needs to turn the microphone on for Mr. Abbott there. I can see him shaking his head, but we need to hear it. Okay. Somebody turn the microphone in Wayne County. Will you turn the microphone on for Mr. Abbott?
Can you hear me now?
Yeah, I can hear you now. Okay. Mr. Abbott is here on a diversion revocation on 20 CR 0063. What does the Commonwealth have to say?
Your Honor, this is our motion to revoke. Mr. Abbott had a possession of a controlled substance 1st degree. He was pretrial diverted on that. He was placed in drug court after he had an initial violation, and he was terminated from drug court on or about June of this year. And one of the violations was he absconded, and the other was positive tests.
Ms. Costello, you want to stipulate?
Your Honor, I have spoken to Mr. Abbott and he does wish to stipulate to those
We'll
violations.
stipulate, we'll order a pre-sentence investigation report done. We'll revoke the pretrial diversion order, pre-sentence investigation report to be done. Come back on the 17th of November for sentencing, okay? Thank you very much. Wayne County, that's all we have with you. Thank you for your cooperation. You may be excused. Barron County, looks like you just have a couple, maybe three, if y'all come on, and then we'll do Grayson County next. Barron County. Barron County. Barron County Detention Center. Okay, well, let's do it one at a time here. Commonwealth versus Austin Brown. Austin Brown for arraignment. This is 22 CR 0081. Mr. Brown, do you have an attorney?
No, sir.
Let me have his file for arraignment. It appears that you are qualified for a public advocate, and I will appoint one. Ms. Costello is on their way, Mr. Costello, so this gentleman can see you.
I was wondering if there's any way to address bond today.
Well, let me get you, I just now appointed one. The grand jury of Cumberland County has returned an indictment charging you with criminal syndicate engaging in organized crime, theft, unlawful taking, more than 10,000 but less than $1 million, complicity to criminal mischief, second degree, and being a persistent felony offender. Do you acknowledge the receipt of the indictment, Counselor? Bailiff,
Yes, sir.
place it on. Place this on the back with the public defender back there. Take it back to her, okay? You acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay. What is the bond in this case? 10,000 cash. I would assume that the reason is because there's these PFO charges and other charges pending an amount of theft. What does the Commonwealth say?
Your Honor,
Mr. Latham, or can you turn your camera off to your cases call?
yeah, I've reviewed all three of these are co-defendants in Barron County. They all have a substantial criminal history. I would need a bond here and I would request before we reduce the bond. Okay, well, we'll let y'all discuss the matter with each other. We're here for the discussion for negotiations at November 4th at 1 p.m. and November 17th is the next court appearance. Okay, thank you very much. Amber Huff. Commonwealth versus Amber Huff. Yeah. Are you Amber Huff?
Yes, sir.
This is 22 CR 0079. Ms. Huff, were you born in 1999?
Yes,
The last four digits of social security number 1037.
yes, sir.
Okay, you're here for the purpose of arraignment. Do you have an attorney?
No, sir.
I see the form is filled out here and it appears that you are eligible for a public defender, so I will appoint you a public defender today. Ms. Costello, wave so she can see you there, okay? The grand jury of Cumberland, you have a right to remain silent. The grand jury of Cumberland County has returned an indictment charging you with criminal syndicate, organized crime, theft of unlawful taking more than $10,000, less than $1 million, complicity to criminal mischief, and being a persistent felony offender on the theft case and on the syndicate case. You understand those charges? Counselor, do you acknowledge the identity of your client, receipt of the indictment, which is on the way back to you? Waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions for Ms. Huff.
Yes, Your Honor.
And November 4th for the negotiation at 1 p.m. and November 17th for the next court date. What's her bond? Okay, well, we'll do it the same way as we did Mr. Brown. You can, after you become familiar with the case, Ms. Costello, you can go over and meet with your client. Now, I would assume there might be a possibility of conflict in these cases. So once you interview them, if you move expeditiously to inform the court that they need conflict counsel, it would be good. Okay.
Yes, Your Honor.
Ryan Moore.
Yes, sir.
Cromwell versus Ryan Moore, 22 CR 0080. Are you Ryan Moore?
Yes, sir.
Were you born in 1988?
Yes, sir.
Last four digits, social security number 6354. I see you've also filled out a form.
I have, Your Honor.
You
I was
looks like you make pretty good money when you work, but you're incarcerated now.
And I also have a paper fax to y'all. It's a paper from J&M saying that I still got my job upon release. I was a lead hand for a factory here in town. I've been there a little over a year. And they wrote a letter and faxed it to y'all and mailed me one. And it's a letter stating that I was employed for J&M since November.
Wait just a second. We'll get to that. Okay. I'm just going over your affidavit to appoint you counsel. So I'm going to reserve the fact whether you want to get private counsel or not today. You can decide that later. But I'm going to appoint for the purpose of arraignment. Ms. Costello. The grand jury of Cumberland County has returned an indictment.
Yes, sir.
Charging you with criminal syndicate, being involved in organized crime. Theft and lawful take over 10,000 with less than $1 million. Complicity to criminal mischief. And being a persistent felony offender on 2 of the charges. You understand those charges?
Yes, sir.
Ms. Costello, you acknowledge the identity of your client, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your
Now,
Honor.
to all 3 of the defendants there, before that, you'll be back on November the 4th at 1 p.m. for negotiations and November 17th. Is this gentleman's bond the same amount? Okay. Now, your attorney will be over there, but if all 3 of you can hear, Mr. Brown and Ms. Huff and Mr. Moore, can all 3 raise your hand if all 3 of you can hear? Okay. This public advocate is going to go over there and interview you. There is a possibility that there will be conflict where she can't represent all 3 of you. If something that one of you said might incriminate the other or that sort of thing right there. She'll know that pretty quickly after she sees you. And so there will be necessity for you to obtain private counsel, or I can appoint what we call conflict counsel to represent you. So each one of you will have your own lawyer. Y'all all understand that? Now, sir, you were wanting to talk to me about your job and bond and that sort of thing.
Yes, sir. What I was asked is I was on home incarceration, and Judge Alexander here said that he would consider putting me back on home incarceration if I could take care of the bond and penalty. I have a great job, and I kind of feel like, I need a good defense for this case. I would like to pay for it, but I can't do it from in here.
Okay, Mr. Stockton, on the situation here as far as this gentleman's bond is concerned.
I would need to get his paperwork, whoever his attorney is, verify his employment look at the case. I might very well agree to it, but I need some information. I
Okay,
need to
there's a
know
letter in the file here from Charity Harvey, the Human Resource Manager from this
Yes, sir.
JNM Kentucky LLC. He's worked there since November of last year. He's a team leader there, they say. Started out as a press operator.
I'm to the point, nothing against the defendant in this case. I like to verify anything in writing because I've been presented forgeries before. I ain't saying he did that, but I'll
Okay,
have
well,
my
I'll
staff
provide
get
you
a
a
copy of
copy.
it.
I'll provide you a copy of the letter here today. It's in the file. And as
I
far
can
as
call
that goes, y'all can do an agreed order. If he is employed at this place and is going to be there, I probably would not have an objection to do an in-home incarceration with an ankle monitor on, so he can continue to work. I'll consider the same thing on the other two. Okay, thank you very much.
Thank you.
Barron County,
Your Honor,
yes.
if I may, we have a case, Joseph Slayton, who was on for revocation in 20 CR 55. He's a state inmate and was at a jail, I think Bullitt County, and we couldn't get him on Zoom. He was actually moved to Barron County for court there, and I didn't know if it would be possible to add him today. He just wishes to stipulate and be revoked.
What's his name?
Joseph Slayton.
Y'all have Joseph Slayton there?
We have Joseph Slayton.
If you want to stipulate, let's just do an agreed order revoking him.
Yes,
Well, I
we
didn't
have.
know.
Well, could you bring him up just for a second and we'll just get him on the air there?
They're going to get him, Your Honor.
Thank you so much.
You're welcome.
I don't know the case number.
Grayson County, we're coming right at you as soon as we finish this right here.
Mhm. He's the one that conned the.
Your microphone's, there you go. Give me his full name again, Ms. Costello.
Joseph Slayton, Your Honor, and it was 20 CR 55.
How you spell his last name?
Slayton.
55 or 65?
55, and then he had 20 CR 75 that was, I believe, consolidated because it was the PFO charge.
Okay. Said it got dismissed.
Yes, the PFO did.
Okay.
Can Jessica tell our office when the judgment was entered? That way we can prepare the order, Your Honor.
9/30/21. 9/30/21.
Thank you.
20 CR 00055.
He's coming, Your Honor.
Okay. Yes, sir. Would you identify yourself?
Joseph Slayton,
Mr. Slayton, what's your year of birth?
7/31/1980,
Last four digits of social security number.
2977.
And this is 20 CR 0055. Ms. Costello, there was a situation. You explained to your client where we are on this.
Yes, Your Honor, Mr. Slayton, or Mr. Stockton filed a motion to revoke Mr. Slayton's probation in this case. He has since become a state inmate. And as my understanding, he wishes to stipulate to the revocation motion in Cumberland County and be revoked on that time.
Is that correct, sir?
Yes, sir.
Okay, well, I will sign the revocation. Thank you very much, Barron County, for your cooperation. You're excused. We'll next go to Grayson County.
Thank you, Your
Grayson.
Honor.
Okay. Grayson County. Mr. Lanham, you have a case right now? You turn your camera off until your case is called. Okay. Commonwealth, Grayson County Corrections. Grayson County Detention Center. Grayson County.
Yes, sir.
April Nethery, turn your camera on, please. Okay, let's do April Nethery first, and you can turn Mr. Otterson's camera off there. Turn Mr. Otterson's camera off, and we'll do April Nethery, and then we'll come to Jimmy Otterson, okay? Okay, Commonwealth versus April Nethery, 20 CR 0066 and 21 CR 0039. Are you April Nethery?
Yes, sir.
You born in 1981?
Yes, sir.
Last four digits, social security number 5139. What does the Commonwealth have in Miss Nethery's case?
We have a felony plea, Your Honor.
Okay. Ms. Nethery, a motion has been filed that says you wish to enter a plea today. Is that correct?
Sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in 22 CR 0066 and 21 CR 0039?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this charge with your attorney?
Yes, sir.
Are you satisfied with his advice, with her advice rather?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? You feel like you're fully informed about your case?
Yes, sir.
You have certain rights under Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Right to be trial by jury. Right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence. Right to call witnesses in your favor. Right to fill a matter higher court if you lose. And right to require the Commonwealth prove beyond a reasonable doubt that you're guilty charges against you. Understand that by any today. Give up those charges. Now I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided law. I do not have to accept any recommendation. Prior to accepting any recommendation, I will await the pre-sentence investigation report that is done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. Mr. Stockton, what is the Commonwealth's recommendation?
Your Honor, Ms. Nethery will plead to trafficking in a first degree 3 counts in case number 21 CR 39, receive a sentence of 5 years on each charge to run concurrently for a total of 5 years to serve. In 22 CR 66, she'll plead guilty to possession of a handgun by convicted felon, receive 5 years to serve. All those sentences will run concurrently for a total of 5 years to serve. The Commonwealth will oppose probation and she will pay court costs at the discretion of the court.
What's the court cost in this case?
$210 on each case.
Okay.
Your Honor,
200
would the court consider waiving those due to length of
Well,
restraint?
let me get to my point here first, you know.
Sorry.
Don't be interrupting dog here now.
Sorry, Your Honor.
There's $210 on each one of those. Considering that she's going to be incarcerated, I'm going to merge all 3 of those into one court cost of $210 instead of $630, and she can pay the first payment $30 30 days after she gets out. Is that what this is what you've agreed to, ma'am?
Yes, sir.
You understand that entering this guilty plea here today that you have felonies in the futures, they can be enhanced under persistent felony offender law, right?
Yes, sir.
Understand that? Okay. Is that your signature on the docket, Ms. Costello? Now it's your time. Now hold that up there. That is your signature there? Okay, I will accept the agreement. Is this lady a state prisoner?
She is, Your Honor, but she did not wish to waive a final sentencing.
Okay, well, we'll order a pre-sentence investigation report to be done for probation and parole. You can come back here on November 17th for sentencing, okay? Thank you very much. Now let's go over to Mr. Otterson. Ms. Nethery's camera can be turned off and Mr. Otterson. Can y'all turn Mr. Otterson's? There's Mr. Otterson, come back in. You need. Okay. Mr. Bates, you can turn yours on. Mr. Bates. Mr. Bates, Eric A. Bates.
Yes, Judge. Can you hear me?
Yeah, I need to see you. Okay, Mr. Bates, the Commonwealth wants to approach about something. Do you have a phone number that I could call you on so we can get you in on the conversation without broadcasting on Zoom?
Yes, Judge. It's 502.
Wait a second.
Okay, sorry.
502, okay.
210
Okay.
0794.
0794. Okay, everyone else will be right back on Zoom for your other county jails. Okay, now, Mr. Eric, Attorney Eric, will you get back on there? Okay, now, the Commonwealth Attorney approached and said there's a scheduling problem and that you need to have this rescheduled. Is that right, Mr. Bates?
That is my understanding, Judge.
Mr. Bates? Yeah, okay, so we'll reschedule this for December the 15th. Is that okay, Mr. Stockton?
Yes, and Mr. Bates, just get with me
And,
next.
and if the scheduling
That's an issue.
conflict is taken care of, I can enter an order before then. Your attorney will be calling you, Mr. Alderson, about the rescheduling, okay? All right?
Yes, sir.
Okay, thank you very much. Thank you very much.
Thank you, Judge.
Now, let's-
Thank you, Judge.
Yeah, let's go to Hart County. Are you ready? Hart, Marion, and then Taylor. In and up in there. Hart County, are you on there? Grayson County, we're finished with you. You can be excused. I don't see Hart County on there. Let's go to Taylor County. Taylor County,
They're on.
there's Hart.
Yes, sir.
Taylor County,
Yes, sir. Good morning.
hey, good morning. Could you turn your camera on at Taylor? There you are. Yeah. Commonwealth.
Looks like.
It's 2 years ago when the pandemic hit.
Mr. Stockton.
Today, it's 108.
Hart County. No, I'm not muted. Hart County, if you'll turn your camera off, we'll be right with you next, Hart County, okay? Mr. Stockton, your microphone must be muted here.
I'm on now, Your Honor.
This is Taylor County. Mr. Kern Cost, who's been identified on a probation revocation. What do you have to say?
Your Honor, I have, he has a 3-year sentence. I got a report from Chris Wilkinson that he absconded. He's on to testify. I'll just put him on. It's a be short testimony.
Your Honor, if I may, I represent Mr. Cost and I spoke to him and he wishes to stipulate to the violation.
Okay, well, we'll revoke the probation and enter an order. Okay? Thank you very much. Is that all we have?
Thank you, Judge. May I be excused?
Absolutely.
Thank you, sir.
Yeah, thank you. Okay. Now we have, I guess we have Hart County now. Hart County.
Are we free to go, Your Honor, at Taylor County?
Taylor County, we're finished with Taylor County, yes.
Okay, thank you.
Thank you very much, Taylor County. Hart County. Hart County.
Present.
Taylor County, you can turn your camera off. You're excused.
Unmuted.
Hart County, we're good now. Commonwealth, Kentucky versus Richard Pitcock, 18 CR 0021, motion for shock probation. Did you file as counselor?
I did, Your Honor.
Okay, could you proceed then?
Yes, Your Honor. Your Honor, Mr. Pitcock was sentenced by this court on May 26 of 2022. He has since served, as of September 30th, 127 days. He was given credit of 179 days prior to sentencing. So of his sentence, he served 306 days as of September 30th. So he would have some additional time, Your Honor. Mr. Pitcock, and we do acknowledge that he was given some opportunities prior to being revoked to try and get things situated. He was unable to figure everything out, but now that he is
What was
sat.
the underlying charge? Mr. Stockton, Mr. Stockton, you need to put your microphone on.
5-year sentence. He had 3 counts of wanton endangerment.
Yes, Your Honor.
What was the fact situation, Mr. Stockton?
Looks like he had 3 passengers with him, Your Honor. He, according to this, that there was some alcohol involved. He was driving a truck, sliding side to side on a gravel road and struck a tree and overturned. And he had 3 passengers. And that's the reason he got the 5-year sentence on each passenger.
Now, what's your position on shock probation?
Your Honor, the problem I have is he was given 5 chances on probation. We filed 5 different motions to revoke. Then he was placed into drug court and he was terminated from drug court because of 5 positive tests. He had a job at Tyson and quit, and he wouldn't follow the directions of drug court. So I don't know that he would be compliant if you did grant him shock probation. So I
What
would
do you
be
have to say to
opposed.
that, Council?
Your Honor, Mr. Pitcock this is the longest time that he has sat continuously in jail. And when you're given that much time, you really think about where you don't want to be.
Well, I understand all that. When's he gonna be in front of the parole board?
I'm done.
I think he was already deferred, Your Honor. They did not grant him parole. They have deferred.
I'm not gonna act counter to the parole board on this situation without any more information than they reviewed. So I respectfully decline the motion for shock probation. Okay, thank you very much. Marion County Detention Center. Marion County Detention Center.
Barron County is not on.
Marion County Detention Center.
Doesn't appear they are either.
Are they on the line?
No.
Okay.
Please.
Well, somebody needs to try to contact them and see if we can get them on the line. Now we go to Adair County. Will you try to get Marion County on the line, see where Marion County, yeah. Adair County. Adair County Jail. See you.
Marion County had an evaluation this morning, and they was gonna get on and make that evaluation.
Okay. If you get a time certain for us to call Marion County back, I've been informed that they had some sort of evaluation going on. So just tell them we'll defer to them and call them back at the time certain.
Your Honor, that was my motion for shock probation on Mr. Wise. If they're not available today, we understand and we can defer that as long as it's held in advance. We can defer that till next month if that's more convenient for
That'll
you.
be fine. Just forget Marion County for right now. We'll set it up for November 17th.
And Your Honor, on Mr. Weiss's case, I apologize for my error. He had 2 cases that were pled at the exact same time, and I only listed 22 CR 11.
You can file an amended motion.
Thank you, Your Honor.
And Your Honor, on that one, if the court's willing, I would go ahead and have him assessed for drug court. I'd probably be willing to shock him into drug court if he's interested in that.
Yeah, I will sign a referral. If y'all will submit a referral, then by next month, we might be ready to go.
Costello.
All right. Thank you so much, Your Honor.
Okay, Adair County. Speak to me. Okay, Denzel Burton. Denzel Burton. Commonwealth versus Denzel Burton.
Judge, this is Mr. Lanham. If I could have one moment of your honor's time. I think we have a resolution. However, I have not been able to go over the paperwork that the Commonwealth has provided today. Is there any way we could do a breakout room with I have Denzel Burton and then William Burton to finish the paperwork up on the plea deal, your honor?
Megan, can you set them out a breakout room?
I already have.
Okay, Adair County, you just need to go into the breakout room and we'll be able to go over this.
Okay, let's skip over Denzel and William and go to Dale Cross.
Judge, they'll have to go into the breakout room in Adair County.
So they'll have to go to the breakout room and we can't do anything till after then?
Correct.
Judge, would you like me to wait for the
Wait
two?
just a second. Megan, what did you say about that?
Yes, that's correct, because they'll have to go into the breakout room on that computer.
Okay, well, let me finish the rest of the docket and then y'all can go to the breakout room.
Dale Cross. Commonwealth versus Dale Cross. Are you Dale Cross,
Yes, sir.
born in 1958?
Yes.
Last
Your
four
Honor.
digits,
Seven, seven, four, nine.
last
Seven,
7749, your social
49.
security number? Okay.
Yes, sir.
We're here on a probation revocation. You're represented by Mr. Poindexter, is that right?
Well, I'm not on this one. I didn't hire this time. He might, unless he's already took it. I don't know.
Well, do you have an attorney here?
No, I thought with Brian Garner and then him signing the deal. But Brian Garner and my probation officer.
Okay, this is 21 CR 00158. Miss Gordon Anderson, what do y'all have here?
It's a motion to revoke, Your Honor.
Well, tell me about it, and then I'll let this gentleman hear it. I think he needs an attorney. So,
Your Honor, he was, got 5 years. This involved an incident with a gun in Scott Daniels when he went to answer a call. So he received 5 years. He served some time, I think about 6 months. We let him out. Then he never reported to probation for parole.
okay, what I need to do, he needs to have an attorney here.
Yeah.
To represent him. So I'm going to put it on November 17th and let him have a chance to. Can you afford attorney, Mr. Cross, or do we?
No, I can't.
Can't right now, can't. So pre-trial or someone needs to get him, we'll get you an affidavit up there and let him fill out an affidavit, and I'll appoint you a lawyer, okay?
Okay, sir.
Okay, thank you a lot. Parker Purdue.
We've got a little bit of a conflict with the Burtons and Parker Purdue, so I can't have them and him here at the same time.
Okay,
I'm sorry.
no problem.
Judge, the Burtons were the ones we passed to the end of the docket.
I can't hear you.
The Burtons were the ones we passed to the end of the docket.
Yeah, I know. They're the ones that we're gonna have to get in this.
So do you want me, I can remove them and bring him in here if you want me to do that.
Well, I have to have one or the other. It's gonna
Okay.
take some time. It's gonna take some time with them. So why don't you take the Burtons out and lodge them somewhere, and then let's finish the 4 or 5 other people we have on the docket, and then we'll come back to the Burtons, okay?
Okay, give me just 1 second, okay?
I've been incarcerated 8 months, so. Get it.
Okay, here's Parker Purdue. Sorry about that. We
No
just
problem.
have them all in here.
We went down, used to be for lunch.
Commonwealth versus Parker Purdue, 22 CR 0061. Are you Parker Purdue?
Yes, sir.
Were you born in 1979?
Yes, sir.
Last 4 digits of social security number 3571.
Yes, sir.
We're here for a pretrial conference.
Judge, we've gotten the admission paperwork for Mr. Purdue to be evaluated, so we're just waiting for that to occur.
Is there an agreed order on that?
Yes, it's been submitted. We're just waiting for KCPC to evaluate.
Okay. Okay, I will
the surety is requested to come off the bond. So since he's in custody, I will release the surety off the bond. And he's to be held without bond right now. Is he gonna have an inpatient or are they gonna come see him there in
Judge,
jail? Or what?
I think they're going to do an inpatient from what the admission paperwork showed.
Okay, Mr. Purdue, you can expect to hear from KCPC and they'll probably try to do one online. It's what they're doing now. Isn't that right, Mr. Stockton?
Yes.
Okay, thank you very much. Lake and Robbins.
Discovery.
Lake and Robbins for arraignment.
Text Ken, see if he's, I think he's doing it. You might want to double check with him.
Commonwealth versus Lake and Robbins, 21 CR 0098. Are you Lake and Robbins?
Yes.
This is, you're here today for the purpose of arraignment. You what? Dustin Warren, are you on the line? An attorney by the name of Dustin Warren entered appearance, but he doesn't seem to be on the line here.
Your Honor, he was, I don't know if he withdrew or not. He represented her and Mr. Rodney Miller, who were co-defendants at one time, and then they absconded and I had to get them an NCIC. I just don't know if Mr. Warren ever withdrew or not.
Okay, well, I'm gonna ask. Yes, ma'am.
He told me that he was in the process of becoming a prosecutor.
Okay, well, you have the money to hire another attorney? Do you want me to let public advocacy come in?
I'm going to need a public defender.
Okay, well, so I'm gonna have public advocacy come in subject to, for the purpose of arraignment, subject to review of your application. You have the right to remain silent. Ms. Robbins, the grand jury of Cumberland County has returned an indictment charging you with receiving stolen property, possession of controlled substance, first degree, possession of drug paraphernalia, possession of marijuana. Take that back to the public defender. You acknowledge the identity of your client received in that way, formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Yeah, I have a copy of the order here that I'm signing as far as appointing public advocate, the affidavit that's in there.
Thank you, Your Honor.
Okay, we'll have a negotiation on this case on November 4th, next court appearance on November 17th.
Thank you, Your Honor. Ms. Robbins, I will be to the jail to see you next week, okay?
All right, thank you.
Corey Sanford.
There
There was an affidavit in that one. There already was. Corey Sanford. This is 22 CR 0036. Are you Corey Sanford?
Yes, sir.
Okay, what are the last four digits of your social security number?
4109.
And you're born in 1990.
Yeah.
This is a probation revocation. What do you have to say, Mr. Stockton?
Your Honor, Mr. Sanford has a 4-year sentence on 2 possession of controlled substance first degrees. He was terminated from specialty court. He had excessive positive tests and there was an issue where he was supposed to remain in custody. He left the courthouse. So we're asking he be revoked.
Your Honor, I've spoken to Mr. Sanford. He does wish to stipulate to the violations.
Okay, we'll take the stipulation and enter the revocation. Thank you very much. Deshaun Tucker. Deshaun Tucker. Are you Deshaun Tucker?
Yes, I am.
Okay, this is You're here for arraignment in 22 CR 0067. Sir, were you born in 1972?
Yes, sir.
Last four digits of your social security number 9066.
Yes, sir.
Okay, are you it appears that you're eligible for a public defender. So I'm going to appoint someone to represent you. Ms. Costello, wave there so he can see that you're on the line. You have the right to remain silent, sir. The grand jury of Cumberland County has returned an indictment charging you with possession of a handgun by a convicted felon, possession of drug paraphernalia, and possession of marijuana. You understand those charges?
Yes, sir.
Okay. Stacy, take that back to her. Counselor, do you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
Okay. We'll set a conference date for negotiation on November the 4th and the next court date on November 17th. You can, after you meet with your client, you can discuss his bond situation, okay?
Mr. Tucker, I'll be there next week to see you, okay? I'm hoping for Monday.
Okay, thank you very much.
Thank you.
Joshua Vibbert.
Yes, sir.
This is Commonwealth versus Joshua Vibbert for sentencing, 22 CR 0021 and 22 CR 0069. For sentencing, your attorney, Mr. Cross, has his associates standing in there. You see him wave there so he can see you.
Yes,
You
sir.
had an opportunity to review the report by probation, pre-sentence investigation report done by probation and parole.
Yes, sir.
It's substantially correct.
Yes, Judge.
Counselor, is there any reason this gentleman should not be sentenced today?
No, Judge.
On a plea of guilty to fleeing and evading 2 counts, the defendant shall receive a sentence of 4 years on each charge running concurrently for a total of 4 years. The sentence in 22 CR 0021 in 69, he shall receive a sentence of 4 years on each charge to run concurrently for 4 years. Sentence in 21 and 69 to run consecutively for 8 years, probated for 5 years. The defendant shall serve 148 days, shall receive 148 days in jail, and shall serve an additional 68 days on in-home incarceration after his sentence. He shall complete the specialty court and remain incarcerated until the morning that he gets out on that. Okay? I'll sign the document. What would court cost this case? What? $255. $255, and when you get out, you can start paying it $30 a month. Okay.
Sir.
And also, when he gets ready for the ankle monitor, counselor, you need to help line him up for that when he gets ready to get out for drug court. When he
Yes,
gets
Judge.
out for drug court to put the ankle monitor on him. Okay.
Yes, Judge.
Okay. Thank you very much.
Thank you, guys.
Yeah. Jacob Voorhees. Commonwealth versus Jacob Voorhees. Are you Jacob Voorhees?
Yes, sir.
Okay, this is 16 CR 0077 and 20 CR 005. Were you born in 1991, sir?
Yes, sir.
Last 4 digits, social security number 5782.
Yes, sir.
Okay, this is a motion for shock probation filed by Mr. Cross. Are you standing in for Mr. Cross?
Yes, Judge.
Okay. What's your motion?
As you can see, Judge, we've attached several medical records and the affidavit of the nurse in Adair County Jail. Mr. Vorse unfortunately has been diagnosed with multiple sclerosis, MS. His condition has deteriorated significantly this year, and particularly while incarcerated. The nurse informed me that his last MRI, which I believe was about a week or two ago, revealed significant new lesions on his brain. He has significant vision impairment. He requires, again, significant treatment each week and monthly treatment. He has monthly treatment with doctors in Louisville that he's having to be transported to. Also, he's currently trying to obtain Social Security disability. He has a doctor appointment this Saturday, actually, that regarding his disability, that the jail is going to try to get him to as well.
What was the underlying chart, Mr. Stockton? What's the underlying charge here?
I don't know if he knows his microphone's on mute.
One case, he had a possession trafficking case. And in 19 CR 29, he had a tampering with evidence. I believe it was a possession case. Yeah, alcohol intoxication, assault, 4th degree.
Judge, Mr. Vorse is a resident of Cumberland County. His family's in the courtroom today. They are willing to let Mr. Vorse live with them and support him. They will assure that Mr. Vorse will not drive, and Mr. Vorse is willing to accept any conditions set by the court, including home incarceration or monitoring. But as you can see by the affidavit by the nurse, his treatment does require significant treatment each week and month, and his condition has deteriorated since incarceration.
What do you have to say, Mr. Stockton?
Your Honor, Mr. Voorhees amply deserved to be revoked. I've read the affidavit. I've looked at the records. I would be willing to shock probate him on humanitarian grounds if he would agree to surrender his driver's license to the Department of Motor Vehicles. He would agree not to drive, not operate any kind of motor vehicle on the public highways, because I think he would be a danger to himself and others. And that would be the key thing that I would emphasize.
And I believe he'd be willing to do that. Am I correct, Mr.
Yes,
Board?
sir. Yes, sir.
Well, I've reviewed the affidavit by Miss Amanda Stevenson, and I will tell you that in my experience with this individual or with the Adair County Jail, that they're very conservative, Mr. Stockton. Would you agree with that?
I agree. I was impressed by her affidavit.
Pretty conservative. They try to take care of the well-being of their convicts up there. So with the stipulation of surrendering the driver's license, operating no vehicles on or off the highway, in-home incarceration with his parents, is that where he's going to live?
Yes, Judge.
With his parents, and they'll do the transportation to and from the medical things. He can go to church if he wants to. They can take him to church or the doctor. Other than that, he shall stay in-home incarcerated. If he has any other need than that, they'll need to call his probation parole officer if something else comes up other than that, okay? So
Yes,
if you'll
Judge.
submit the order, I'll get it signed.
Yes, Judge.
Your Honor, I'd ask that I just be furnished proof within 30 days that the license has been surrendered.
Okay, well, he'll have to give proof before he gets out.
Okay.
I don't have a driver's license at this time because my last DUI has already been surrendered.
Okay, that'll be good.
Thank you, Judge.
Yeah, when
I want him put on the ankle monitor and then he can come see you. Okay. His parents are still there. Mr. Cross, you need to make arrangements to get him on the ankle monitor. And when he gets on the ankle monitor, I'll sign a release for him to go up and see probation pro. Or you just call him up at the jail. Would that be better? You what? Yeah, they'll have to call him at the jail first and interview him, then they'll get an ankle monitor on him. Okay, thank you. James Whitlow. James Whitlow. Commonwealth versus James Whitlow for arraignment, 22 CR 0083. Are you James Whitlow?
Sure.
You have an attorney?
No, sir.
I see there's an affidavit here, I think, in there. Okay, I'm going to sign an order. Make sure I sign an order. I'm going to appoint public advocacy. It's going to take about a 1-minute break here. I'm going to go offline here. I'll be right back. Okay, let's go back on the record. We're here at Commonwealth versus James Buddy Whitlow. Ms. Costello, you get on the line.
Yes, sir, I'm sorry.
Are you James Buddy Whitlow?
Yes, sir.
Were you born in 1985? Last 4 digits, social security number 2662.
Yes, sir.
The grand jury of Cumberland County, represented by counsel, grand jury of Cumberland County has returned an indictment charging you with 3 counts of kidnapping, trafficking in controlled substance 1st degree, tampering with physical evidence,
fleeing or evading police in the second degree, possession of controlled substance in the second degree, resisting arrest, possession of controlled substance not in original container, public intoxication, and PFO on trafficking and kidnapping. You understand those charges?
Yes, sir.
Counselor, do you acknowledge the identity of client received the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
You would set this for negotiations on November 4th, and the next court date is November the 17th. Now let's go back up to the Burtons and do the side room, okay? Burtons want to come back up, and Miss Megan, will you establish them?
It's still there. I will have to enter the room in Adair County.
I've never, how do I do it?
I've never done it from this end. I've only set it up.
Okay, what we're going to do is we're going to continue this case until November the 17th. And counselor, you be here in person on that day. Okay, thank you. I don't know that. Okay,
Are you guys there?
look, I can't be responsible for sitting. Did you, Megan, they don't know how to set it up at the jail, is what they told me.
Okay.
Is that right, Megan? Megan?
That's what they said.
Yeah.
I've never, sorry, I've never
It's
done the break room before. I don't know how to do it. I mean, if y'all want to,
They should just have to hit the screen and it should immediately go over. There should be something to pop up break room. It's popped up on mine. But if we can't do this, I can come by there, join break room.
I don't see it. All I've got is you all up here and Bethany.
Okay,
Yeah,
thank
I don't
y'all.
have
Thank
it.
y'all very much.
Man, that's crazy, man.
Sorry about that. I don't know.
Okay, now what
Sorry.
I have a show call.
Judge, if she's not able to do that, I guess we need to reset this for your next day.
17th,
Thank you, Your Honor.
November 17th. Okay. Mr. Stockton.
Yes, Your Honor.
Somebody needs to come here and just sit in on the show cause docket, any one of you. Just be.
I'll send Mr. Hunley.
Mr. Hunley, I think you can handle that.
I don't know, Judge. I may object.
What is the 18 CR 045? What is that for? $660. Now, on the show cause docket, these are going down to people who have not paid fine and court costs over a while. And they've all received notice, correct?
We got his mail. $500 fine.
Okay, issue a bench warrant for Kevin Lee Adams. Purge himself by paying the amount in full. $660.
You want to do pay your stuff?
Yeah. Get 60 days. Pay your stay. Brendan Allen.
He's actually.
Do what?
He's in a different jail.
Okay, well, give him a notice to pay or stay $660.
And he, and they convert that time.
But what's he in jail?
He got unsupervised probation for this charge here.
No, these fines are not. What's he in jail for now? For just pass him over and have him here on November 17th. Jesse Scott Allen,
He's in the children.
pass him over to November 17th. Anwar Barber,
He's in Taylor.
pass him over to November 17th. Gerald Beckman,
He. We got return mail on him. We called him.
they have a bench warrant. They are paid bench warrant on $825. Frederick Bishop,
He got a new address from probation for all of you. Did you resend his notice?
do what?
We got a new address, we sent the wrong address.
Okay, have him here on November 17th. Anthony Blackwell,
You got his mail back and we resent it back up to us.
that was the bad address.
We never got. Yeah, we got it back and then we sent it back out to another address we found. But we've not got that back.
We do a bench warrant, stay of pay. James Blakely,
We got any more.
you what?
We got any more you back on him, we don't have the address.
Do a bench warrant, stay of pay. Cynthia Branham,
We done her tomorrow, we got her back and we didn't get her mail back, so.
do a bench warrant, stay of pay. Kurt Cottle,
He can be green reflection.
pass over him. For December the 15th. Benjamin Clavel,
He's in the Lincoln, yep.
pass over him. December 15th.
Judge,
Yes,
I know from Clinton County that he will be incarcerated quite a while, he's on multiple charges, and it's already been revoked to stay in one charge, and he's facing a murder charge as well. He will not be out of this.
wow. Very well. Tanya can answer,
She is also in Clinton County.
pass over. David Davidson,
He has active influence right now.
Okay. issue another warrant for him on this, $130. Randall Dickens,
He's here.
okay, Commonwealth versus Randall Dickens, 18 CR 0046.
Mr. Dickens was in long-term treatment and was recently got out and had surgery. He would like some additional time payments to vote allowance.
Okay, how much can you pay today? Okay, I want you to pay $30 a month, starting 30 days from today. Okay. Thank you. Okay. Jennifer Deal,
She contacted us, said she'd pay, and we haven't heard from her yet.
just $25 to bench work, state pay. Devon Elliott,
We got a new address on her probation roll. She just needs new dates. We haven't sent that out to that yet.
November 17th. Bradford Flowers.
We have that address on him. We got this bill back.
He paid $1,630, he owes you 25, is that right?
Yes, sir. His case was dismissed. It's just the remaining bond on David's left.
Set him for December the 15th. Patricia Floyd.
We haven't heard anything out of her. Didn't get him back.
Did you get the mail back?
We did not know.
They put a bench warrant out, 25, stay or pay. Brandon Gadberry.
He's at the Crown Recovery Center. He's gonna be there for at least 6 more months.
Okay, put him out till March of next year. James Garman,
We don't have a good address. We got to go back.
do a bench warrant on him. $25 stay or pay. Andy Garrett,
We got a new address information for all. We just need to find a reason.
okay. November 17th. Raymond Garrett,
He is in treatment.
put him out for March this coming year. By the way, you're doing an excellent job.
Thank you. That's like they've all got a pretty good excuse.
Juanita Gross,
We didn't get her mail back. And have not heard.
they put a warrant, stay or pay. Craig Hammons,
We got a new address information for all. We just have to find the reason.
okay, November 17th. Roger Harper,
We got mail back on him. We have an updated address on him from the current district case that we can send that to.
okay, November 17th. Brian Hawkins,
He is in rehab for rest involved.
okay, March 31st. Corey Hayes,
We have not heard anything from him. And did not get his mail back.
bench warrant, stay or pay. Sabrina Heaton,
We haven't heard anything from her. Did not get her mail back.
bench warrant, stay or pay. Daniel Hill,
We got a new address on him for production control. We just need to find it.
December 17th. William Hogan,
He has responded from probation control.
okay, bench warrant, $25 stay or pay. Tyler Lee Holland,
We haven't heard anything out of him. We mailed his and probation control let us know that was the address that they had on file. also.
bench warrant. Got another one on him. Combine them, two for the price of one, make it $50 one more. Kevin Gillen, Mr. Humphrey, we got you down to owing $130. That's the reason I didn't issue a bench warrant. I'll give you a chance to pay it, okay? You want $30 a month, does that help you? Okay, make your first payment $30 in 30 days from today. And you can pay all of it anytime you want to. And if you pay it, I won't call you back up here, okay? Okay. Emmett Lawrence,
We did not get mail back on. We haven't heard anything from him.
bench warrant. Pay or stay. Justin Mackey, when that paid,
He did pay that.
okay. Christopher McAllister,
He's at Little Sam.
they put it out for March 31st. Lonnie Moore,
We got a new address.
November 17th. Tricia Morris,
Hers did not come back and we have not heard from her.
okay, it's arrest warrant, stay or pay. Dennis Morton,
He is not. Probation control.
put another warrant out. For Noah Neal,
He is in the American jail. I think.
okay, March 31st. Jamie Overby,
She is incarcerated in Tennessee.
March 31st. Donnie Owens,
His mail has not come back and we have not heard from him.
bench warrant, pay or play. Nathan Eric Pettigo,
His has not come back and we have not heard from him.
bench warrant, stay or pay. $1,045. Victoria Pelland,
We have not heard from her and did not get her mail back.
bench warrant, stay or pay. Timothy Pittman,
He absconded from probation control.
it's your bench warrant. Amanda Relford,
We did not get her mail back. and haven't
bench warrant, stay or pay. Joey Roten,
We resent his, and have not heard from him. The Birchman came back, so.
okay, well, let's give him December 17th. Give him another one, I guess, December 17th, November 17th. Dustin Riddle,
We got an MRU back on him. We do not have a good address.
do bench warrant. Payers, they no payments. Paul Rhodes,
He isn't listening.
March 31st. Danny Savage,
We got mail back on him and do not have a good address.
bench warrant. Payer stay. Daniel Settle,
He is in federal custody.
we will put him out till March 31st. Theodore Sexton,
We got his back the first time, we got a different address and we sent his.
send him another November 17th. When did you send the second one out? On Theodore Sexton, when did you send that?
September 15th.
Do bench warrant. Payer stay. Anthony Ross Shaw,
We got his mail back and do not have a good address.
bench warrant. Payer stay. Robert Benjamin Simpson,
He is in the county jail.
March 31st. Shelley Smith,
We did not get mail back on her and have not heard from her.
okay. Bench warrant, payer stay. Johnny Lee Spears,
We got mail back on him and do not have a good address.
bench warrant, payer stay. Tony Spears,
We got a new address from probation and parole to resend his.
you did
We
reach
have not yet, we just got it.
November 17th. Rhonda Speck,
We got mail back from her. We do not have a good address.
bench warrant, payer stay. Candace Staten,
We did not get her back and do not have a good address.
bench warrant, payer stay. Robert Stevenson,
We got a new address for probation and parole, we just need to resend his.
November 17th. Robert, is this different on Robert Stevenson? You got two of them?
We did two separate cases.
So he's got $4,500. So have him on November 17th. What address do you have on him?
Constance address.
Okay.
That we got from probation and parole yesterday.
Eric Story,
He is in the Russell County.
pass him till, give him another notice and give him on, November 17th. How long is he gonna be in jail there? Stay in May. Okay, give him to March 31st. Stephanie Strong,
We got a new address from probation and parole, we just need time to read it.
November 17th. Candy Stuber,
Same thing, we got a new address to resend to.
send to her and Jonathan and have them here on November 17th. David Terry,
Same thing on him, we got a new address and each time we're in.
November 17th. Elizabeth Turner,
We did not get mail back on her and have not heard from her.
bench warrant. Stephen Turner,
Same thing, no mail back and we have not heard from him.
bench warrant. Donald G. Vince,
Okay, this.
okay? Both of those yet, Joe.
That, yes.
Tabitha Watt,
We got a new address and just take time or something.
November 17th. Robert Wise,
We did not get it back and have not heard from him.
bench warrant, Payer State. Cassie White,
She's in Russell County Jail.
okay, how long is she gonna be there?
She's in state.
March 31st. James Buddy Whitlow, he's in jail, so put him on March 31st. He's got kidnapping charge. Philip Lee Williams,
We got mail back on him and did not have a good address. Even, he's on the active district court docket right now also. He's supposed to be coming back November 16th.
okay, just put a summons on him.
Okay. Thank
Justin Wisdom,
He is in Rover.
okay, March 31st. Another one for this, March 31st. Ricky Wright,
He absconded from probation parole.
give us another warrant for him for his, okay? Pay your play. Pay your stay. Christopher York,
He's in Marion County Jail.
March 31st. Mitchell York,
He absconded from probation parole.
bench warrant from here. Ready to pay. Is that include the docket? Is there anything else coming before the criminal court? If not,
Wait, as long as the internet plays it.
Hello? Can you hear me?
Yes, sir.
Okay, we're going to do an agreed order on your shock probation and put you into specialty court. We weren't able to get you online earlier because there was some kind of scheduling conflict. So your attorney will be calling you and there'll be an order signed and I signed an order referring you to specialty court. So we're working toward a conclusion on it, okay?
Okay, sir.
Okay, thank you, Marion County. Y'all are excused.
of 8 days notice.
Okay, here we are. Going to call a Pulaski County case first, which is 22 CI 00283, Karen Head, surviving spouse of Charles Stephen Head, versus Susan Sloan, Stephanie Head, and surviving children of Charles Stephen Head. Okay, now the defendants have a motion to compel on.
That is correct, Your Honor. That's correct. Your Honor, I'll be brief. We did get a response.
Well, wait just a second. You have both attorneys on?
Yes, Your Honor. Heidi Weatherly represents Ms. Head.
Okay, go ahead. Go ahead, Ms. Hutt, excuse me.
Sorry, no problem. I will try to be brief. We did get a response from the plaintiff's counsel yesterday, and I think I have concluded from review of that response that there probably are no other documents to obtain in terms of the material allegations of the complaint. There is a legal issue, Your Honor. One of the claims in this complaint is that the prenuptial agreement was unconscionable. And the law is very clear, and we've cited this.
I'm having trouble hearing you. Would you speak up just a little?
Certainly. Is that better?
Yes. Well, no, in front of us today was the motion to compel. Do you have another motion on today?
I do, Your Honor. I have a motion for a scheduling order as well, but I do have one further point on the motion to compel.
Okay, go ahead on the motion to compel.
The legal issue we've gotten an objection from the plaintiff to providing her own financial information and information on non-probate assets and benefits she received as a result of her husband's death. And it's very clear, and we've cited in our motion the case of Blue versus Blue, and that's just one of several of this. Blue versus Blue is 60 Southwest 3rd, 585, 2001.
I'm having trouble. Okay, y'all are going to have to hold it just a little bit because I'm having trouble. You're going to have to face the microphone. You seem to be looking to your right on something, and when you face around with the microphone, I'm not hearing you. Okay.
I'm sorry, I was looking at the Blue versus Blue case.
Well, if you hold it in front of you between you and the
Sure, I will do that.
maybe I can hear you.
What Blue versus Blue and other cases of this nature state is that prenuptial contracts are subject to review for conscionability at the time enforcement is sought. And that is true whether it's a death or a divorce. And I'm on page 589 of 60 Southwest 3rd, 585. So
well, let's talk about let's just talk about the discovery you desire. What have you been denied that you wish to have?
Your Honor, specifically, it's paragraph 35 of her complaint and request number 4, 5, and 6 of our request for production of documents. Because she has alleged unconscionability, her own current financial condition and the financial assets she received as a result of Mr. Head's death are discoverable and they're relevant. In fact, it's part of the plaintiff's burden of proof to show that. She would have to show that now, being the time that enforcement is being sought, that its enforcement would be unconscionable in order to measure conscionability.
What do you want from her? Tell me exactly what you want from her.
Certainly, Your Honor. I want her to, request number 4 is to produce a true and correct copy of the most recent financial statement, which reflects the assets, income, and liabilities of the plaintiff. Request number 5.
Okay, I can't hear you. You're going to have to face the screen and the microphone. Okay. Now, tell me again what you want.
Request number 4 is a current financial statement.
Okay, now let's stop one at a time. Do y'all have any objection to giving a current financial statement?
Yes, Your Honor, because the let me get closer. The
prenuptial agreement, the standard in the prenuptial agreement was a list of items owned by each of the parties. And the issue was not the financial status, it's the estate owned by the parties. That's the language that was used. It's not the finances, it's the estate. It's what's included in their estates. The list in the prenup is very clear about who owned what. If she's entitled to anything, she's entitled to a comparable list of what is the same comparable standard of what is in the prenup. Perhaps a lawnmower or a wheelbarrow or whatever. They're not entitled to her personal finances. That was never listed as an asset in the others. So I think we have no problem giving her a list of what she has in her estate, the same as the prenup. But as far as knowing every dime she owns, I don't think they're entitled to that. That's not the standard.
With due respect, it is the standard. Because the plaintiff is claiming that enforcement agreement would be unconscionable, we are entitled to that discovery because conscionability or unconscionability has to be measured at the time of enforcement. So in other words, if the plaintiff is claiming that she's destitute as a result of her husband's death, it's incumbent on her to prove that, or she cannot maintain the enforcement's unconscionable. So we have good reason to believe that she did.
What kind of documents do you want? A certified financial statement, or what kind of financial statement do you want?
Whatever she has available. Is to say, if she's
going to say she doesn't have anything available. What she says, I mean, you're going to have to tell me with specificity what you want.
We have asked for assets, income, and liabilities. The same type of information that a person would typically fill out when obtaining a loan from a bank. We've also asked.
Okay, besides that, what you want? Okay, that's one thing you want, financial statement. What else?
We're asking for true and correct copies of the state and federal tax returns, which report both her income and the income of Charles Stephen Head. And we're asking
what years?
2017 to 2021. And Your Honor, we actually have two reasons for needing that. One is, again, it goes to proof of the plaintiff's claims, both as it concerns contributions to the marriage and as it concerns her argument that enforcement would be unconscionable. We also need it because we are trying to get caught up on the income tax returns because one was not filed, to my knowledge, for 2021 because of Mr. Head's illness and death. Then request number 6 is true and correct copies of all documentation which reflect in any way assets, benefits, income, or payments of any kind which he has received as a result of the death of Charles Stephen Head. This would include deeds of conveyance for joint survivorship property, any financial asset of any kind in survivorship. Any,
Tell her to go to RECC and they need to have them call. Why don't you?
Okay, Mr. George, you need to turn your microphone off, please. Thank you.
Sorry, so joint survivorship asset, Your Honor, real estate, any financial assets, any record of a transfer on death or pay on death designation of account or other asset, and any life insurance policy proceeds. And again, those are all discoverable pursuant to Blue versus Blue and similar cases, which hold that a party claiming enforcement agreement is unconscionable has to show what their current net worth situation is and financial situation is in order to claim that enforcement is unconscionable. It can't be measured otherwise.
Okay. Ms. Worthy, what do you have to say about the issue of unconscionability?
The issue of unconscionability is not, Ms. Huff has misstated.
Will you direct the camera over on you a little bit more? You're over
that
the
better?
edge. Thank you.
I was trying to spare you, Your Honor.
Yeah. I've seen much worse today, so don't do that.
I have no makeup on today. I'm sorry. I was trying to spare you. The issue of unconscionability, Ms. Huff, she misstates the standard. Ms. Head does not have to prove that she's destitute to be able to prove that the prenup is invalid. This is
Well, I'm
just
not
nothing.
talking about the validity right now. I'm talking about the unconscionability. What do you think she has to prove it's unconscionable?
That from the time that the parties were married, what was listed in the prenuptial agreement as their own personal property versus the personal property that they had at the time he died. For instance, they're saying now, if the court will look at the antenuptial agreement, and I think you have a copy of that. If you don't, we'll provide one. I think it lists he listed many things in his estate and about $60,000-$70,000 worth of debt. On Miss Head's side of the equation of the property owned, it included two life insurance policies that are to her children. That's not her estate asset. So there was very little.
I just want to deal with it. You're talking about disclosure things. What is the standard for unconscionability? Just give me a precise answer, because Ms. Huff seems to, wait a second. Ms. Huff seems to indicate that her financial situation, relatively financial situation, has to do with whether it's unconscionable or not. Do you believe that? So what's your standard of unconscionability on this? There's a difference between whether full disclosures were not made. Are you saying that? Or
we have alleged that, yes, is one of the things. That's one of our allegations. But I believe the standard in a nutshell is the amount that each party owned in their estate at the time they married, and the amount of property, personal property they owned at the time of death. The difference there in how much one grew or didn't grow and how much the other one grew or didn't grow is the unconscionability aspect. I don't think it has anything to do with financial money per se. And the court has already ruled that those things were not discoverable. It's already ruled that once.
Your Honor, could I respond to that last statement? Yeah. Your Honor, that was in the context, as you may recall, Mrs. Weatherly sought an emergency hearing with some issues concerning the time and manner of the inventory. That was purely the probate administrative matter of doing the inventory. That had nothing to do with discovering this action. It had nothing to do with prenuptial agreement. I think what the court was saying, at least as I'm understanding the court at that time, was because we were doing the inventory for the estate of Charles Head, that we were not to look at personal papers of Karen Head. And we respected that. But I think, as I say, the case law is very clear that unconscionability has to be measured at the time of enforcement. That
what is unconscionable about this, Ms. Weatherly? What do you believe is unconscionable about the enforcement? Just tell me.
So at the time of the marriage, the value and the amount of property that Mr. Head owned and Miss Head owned when they were married, okay? And at the time of death, her estate did not grow. She does not have more, basically, she might have different bedroom suite or more things than she had at that time.
Are there a lot of cases finding that it's where one's asset grew much more than the other, that it's unconscionable?
Yes, and that's the case law, and I will present those cases to you. The unconscionability is that Mr. Head's assets grew. He brought bulldozers, heavy equipment, more tractors, more cattle, more land, more bank accounts.
Well, isn't that the reason you signed these antenuptial agreements, is because one party is appreciably more wealthy than the other, and that they both one or the other wants to protect their assets? Isn't that the reason you signed them?
Well, there's a lot more to this prenup agreement than just the issue of unconscionability. We listed, I think, 36 reasons why the antenuptial agreement.
I'm just talking about unconscionability right now.
Yes.
That's the reason. I don't see how you can ask her to, how you ask opposing counsel to measure one party's assets versus the other assets, and what grew and what didn't grow, unless you make a full disclosure of what the assets and the growth were. Now, I can understand why you wouldn't want to spread those out to the public. And I'm very, I would, but I'm going to direct you to make full disclosure of
Your
the
Honor,
documents requested.
could I ask you then to limit that scope? Some of those things are not part of the estate. They would not be part of her estate as if she died. So,
Like,
they
what are you
have
talking about? Like, what are you
life
talking about?
insurance policies, payable on death things to her children,
Well, I think
things
they're
like that.
relevant, whether they're part of the estate or not, they're relevant because there are different ways that spouses can provide for each other. For example, maybe one of the parties provided for the other by having life insurance policies that will make things more equitable. I'd want to know, for example, what kind of life insurance policies or what kind of payable on death accounts and where those resources came from and that sort of thing. It appears to me that if we're talking about equitable, whether it was equitable or not, or whether I think that you ought to go ahead and comply with the request of discovery, and I'd like those documents sealed from the public. Ms. Huff, I don't want any copies of those made, any photos made, anything that would interrupt the privacy whatsoever.
That's fine, Your Honor. I would
Okay.
treat those anyway.
Okay, now, is there any other issue that we need to bring up right now? And someone brought us scheduling. Are you having trouble scheduling with each other?
No,
We are,
didn't
Your
even
Honor.
You what? Ms.
We-
Huff?
Yes, Your Honor. We have had some difficulties getting a schedule agreed on. And obviously, I would, like to receive the documents as directed by the court. Appreciate that. Then I would like to take Mrs. Head's deposition. And I've told Mrs. Weatherly that at that point, I'll be happy to make my clients available for deposition. She's certainly entitled to do that. But we've been trying to get a handle on exactly what the nature of the claims were. Because unfortunately, the key other witness to this agreement is deceased. So we need to explore and complete the discovery as best we can of what the plaintiff's case is. And then we can, certainly cooperate with her in getting those depositions of my clients as well.
Well, I'd like for y'all to get together and give a proposed schedule. I pretty much don't push civil cases very much if everyone's cooperating with each other. But for example, I have a trial order that people have to tell me that all the depositions are taken, all the discoveries taken, who the witnesses are, what they'll be saying that are, so I can determine how many days it takes to have a trial. And so we don't have a long wait for a trial. If that's any consolation, if we get down to the point of trial, I can give you a trial within 4 months, 5 months, or something like that, from the time you finish discovery. Ms. Weatherly, what kind of problem? You seem to indicate from your shaking your head that you didn't think there was any scheduling problems. Is that right?
Yeah. Here's the problem I have with this, Your Honor. Ms. Huffa comes to this with her own dirty hands. We noticed one of the things that she's saying is we haven't produced certain things. And at some point in time, Mr. Head's daughter, Susan Sloan, went through the house and removed things from the house when he was sick, to include money and bank records and other things. And we
the only thing you can provide is what you have. You can't provide things that you don't have.
But here's the problem with this. On September 28th, I noticed a deposition to take the depositions of her clients. It was set for this morning. She refused to come. She didn't show up. And she said, I have more pressing matters to do and my clients have other things to do. And this is about a different matter entirely, and didn't show up.
What about that, Ms. Huff?
Your Honor, what occurred, I had already filed the motion to compel the discovery in this matter. I had been asking Mrs. Weatherly for a date for her client's deposition for many months. In fact, I was actually in the court. I was trying to get this hearing rescheduled at that point in time because Mrs. Weatherly said she was not available on the initial date set, and I agreed to reschedule it. Then, without communicating with me on date, time, place, anything, she sent a notice of deposition, and at that point, as soon as I received it, excuse me, I had some buzzing. As soon as I received it, I notified her, Heidi, we've got to finish discovery your client first. I will be glad to make my clients available once we've completed your client's deposition. And I actually asked her, please contact me. Let's try to work out a
Well,
schedule.
obviously, y'all are not going to be able to get along in this thing, and I'm not going to lay blame one way or the other, but I'm not going to, for the next year of my life, I'm not going to have this, this bickering going on. It's not going to happen.
I agree. And I don't want
So,
that either.
okay, now I'm telling both of you. How many days do you think that you'll need to Mr. Weatherly, to comply with this additional discovery that I've ordered today? I want to give you plenty of time to do that.
Hold on just a second, Your Honor. How much?
30 days enough?
I can, if we need an extension for something that we're hunting, I'll ask for the court, but I would say 30 days should be
Okay,
fine.
I want 30 days. And Ms. Huff, how many days will you need to review that from the date you receive it?
Oh, I would think 10.
Okay, 10 days. Okay, at 10 days, if there are not any supplemental requests, you need to contact Ms. Weatherly about taking any depositions that you're
Absolutely.
desirous of taking. Okay, and I don't want you to spread them out because she's got a right to start looking for discovery toward you. Okay, at
Understand.
some juncture.
I have no problem with that
And
at all.
That's enough direction. You start doing those, and within 30 days, after that, I want you to finish your depositions, and then the ball will be over Miss Weatherly's court, and she can depose your clients about whatever she wants to. And at the intervening time, Miss Weatherly, if you think there's additional discovery that you need to help prepare your case and to advance your theory, you do not hesitate. We'll go by Zoom again, okay? Okay, will you
Yes,
draw the
sir.
order generously, Miss Huff?
I'm sorry, Your Honor.
Generously draw the order so we both of you will see it and there won't be any disagreements.
I will
about
do
it.
that. Yeah.
Okay, well,
Absolutely.
thank
Your
you.
Honor.
Thank you all
I'll
very
send
much.
it to Mrs. Weatherly and
Have a
Mrs.
great-
Weatherly. Thank
Have a
you.
great day. Thank you.
Thanks so much.
Thank you, Your Honor. Have a nice day.
Okay, you too. Okay. Patterson versus Graham. Patterson versus Graham and Graham versus Patterson. Okay, what have we got here? You have attorneys? You want to have attorneys? Okay, tell me what the problem is.
He's not letting me see my kids. He's not letting me have my kids. In my custody. And I can understand.
No. Does he have custody of both children?
We both have joint custody. He's got permanent custody.
Okay, the children live with you. How old are the children? Okay, not much you can do with a 17-year-old, but go ahead. So y'all got 3 children together. Is there a problem with the children getting to visit their mother? No, I'm asking you, is there a problem that the children not want to visit their mother, or what's the deal?
No, it's solely on me, it's not on the children. Her current situation house-wise, doesn't allow her, say her physical capacity, violence, the physical.
Well, okay, so you don't approve of who she's married to, or she married to someone or living with someone? Now, raise your right hand. You swear the testimony you're about to give us the truth, the whole truth, nothing but this. Okay. Tell me what the problem is without alluding. Just give me the unvarnished truth about it.
Extensive amount of violence between the two.
Okay, well, who are you talking about?
Yeah.
Who is her husband? Do what? That day. Okay, now how do you know about this violence?
From her.
What kind of violence are you talking about?
They're constantly fighting.
Physically fighting? Okay. Have the children been involved in front? Have they looked at that or seen it?
I think Sydney, I'm sorry, I think Sydney has witnessed it. Fighting
Okay, how much visitation is she supposed to get?
every other,
Okay, have you been giving her every other weekend?
up until the issue is just.
The answer is no. Okay, correct? Okay. Okay, and when did that start, that you weren't giving her every other weekend?
So you haven't given her every other weekend for 2 years? Well, it's been a year or two now. Let's stop here. What's the deal about the violence between, are you married to Matt Day?
Yes.
Okay, and how long have y'all been married? Okay, and then do y'all have any children together?
Yes.
How old?
She's not.
Okay. Now, how have you been getting to see your children, 17, 14, and 12? Where do you see them?
I go to his mother's.
Okay, was that in an agreement anywhere? Okay, was that in a court order anywhere? Okay, you just started demanding that and you did. Okay, okay, now, where do you live? Oakland Heights. Okay. Now, you have a good relationship with your 17, 14, and 12-year-old? Okay. Now, have they ever expressed any problems with Matt Day or how he treats them or how he treats you?
They like him.
Yeah, the answer would be yes or no. They have not expressed any. They haven't expressed any problems they have with Matt Day or how Matt Day treats you. Okay. So you on your own decided that you were going to limit the every other weekend things because you were afraid of what would happen.
Thank you.
Yeah, okay, which, let me tell you, you can't do that. You can't make that decision by yourself. If you've got a problem like that, you need to come into court. You cannot unilaterally make that decision. I'm not saying you're not right, okay? But you just can't do that. Now, I want y'all to go back there somewhere and one of the bailiffs will stay in the room with you. So you'll have a witness about what one of the lady bailiffs sitting back there will stay in the room with you. And I want you to see what we can do to rectify this problem as far as visitation being concerned. And if I have to bring the children in here to see if they want to do it or whatever, but we're going to reestablish some visitation here. But I don't really know enough about it. You might have really good reasons why you have this fear. You just haven't been able to express them to me yet. See what I mean? And we suspect a lot of things that might happen that don't happen, but after this period of time. So y'all go back down there and see if you can work this thing out somewhat and then come back out here and talk to me about it, okay? Will one of the bailiffs go in the side room with them there? Thank you. Okay, Graham versus Patterson with the second case. Both of those cases involve those folks. Chambers versus Chambers. Hello, how are you? I'm blessed, thank you. Now, you filed a motion to alter, amend, or vacate, and then the commissioners, the Domestic Relations Commission report, and you filed an amendment to adopt. Now, because the way to think, let's break it down to the few issues that you have problems with. And I'm going to accept your motion to alter, amend, or vacate as filing exceptions. I knew you're not used to practicing where they have commissioners, so they call them different things, okay? Oh, it's okay, it's no problem. Okay, what are the main problems that you have with findings commission? How many issues do we have? You just don't like any of it or what? Okay, well, let's go through them real quick.
The first issue would be, we would like to have the exchange located in Monticello. And just make sure that that's the halfway point.
From where? Halfway from where? Yeah.
Judge, we're going to go on the divorce decree. They will be the junction station in Albany.
Where did they both live at the time?
He was living in Cumberland here with Miss Chambers at the time of divorce, and they.
He's moved back to McQuarrie, which I understand is a beautiful place. I've been to Strunk, you know. But I don't believe the fact that he decides to move somewhere else should be reason to modify an agreement about where they're going to exchange. So let's go to the next one.
Next issue is the they agreed that she would have the house, get that out of her name. Or I'm sorry, out of his name.
Yeah.
And that's
You have a mortgage on it And she hasn't gotten it out and got it refinanced. What do you have to say about that, Ms. Perry?
Judge, I think we agreed upon 90 days of the commissioner's hearing. It's a USDA loan with the federal government, we all know federal government.
So she acknowledges that she needs to get it out of his name.
I have emailed her where she's been making.
Okay, well, I will depend upon you to make an expeditious and keep them informed about that. Okay, and what's the third issue?
And on that, we would ask that that's what I think the only issue with it was we agreed on for that name.
Okay, well, 90 days is fine with me. I was gonna push it quicker than that, but if you want to do 90 days, fine, 90 days seems reasonable. Okay, and what's your third issue?
Okay, for the house payment is being behind. She's supposed to keep up with those payments.
Okay, well, the house, if they close and get refinanced, and obviously she'll have to take care of the house payment, so you protect her on that. Okay, and what's the fourth issue?
The other, we would like to reconsider, Commissioner did make recommendations. So we're already just not heard. He has complied with that, so she'll get it in school and cooperate and make that recommendation.
Yeah.
He would just ask that the board, once we go back and look, hear it and anything involved. She brought up great things, about the veterans flag supervision.
How old is the child? Okay. What is the fifth one then?
Okay, the fifth issue is, in the event that the court doesn't consider, I guess we need clarification, on what summer visits are, and we both actually agree.
The commissioner's recommendation said she's to be primary residential parent with him receiving every other weekend invitation. However, that schedule is reversed during the summer months, which means Mr. Chambers would be primarily with children the majority of the summer. Yes, and so other parents get 2 uninterrupted weeks of
Yeah.
vacation.
Okay, do you object to that? No, I'm talking to your lawyer.
No, he just, we get people there.
Well, you just work out some dates and times when school starts and when school begins. That's how you're gonna have to phrase the 2 weeks. You want, and is it 2 continuous weeks?
I think it says 2 uninterrupted.
Uninterrupted, even with visitation? I don't know how I feel about that, but if that's, I think that there ought to be something in there about contact between each parent during that 2 weeks uninterrupted. There should be phone contact set out, and obviously. Okay, well, okay, that takes care of the fifth one. And what's the sixth one?
Last one just says the issue. We just have to reiterate that not a parent. The definitely issue with the children.
Status quo. I'm real big on status quo. Let me tell you something. Either one of you will regret slurring the other parent at all. Sometime in your life, it will come back to bite you because it damages the child and makes the child think that they cannot have a reasonable expectation of having a trusting relationship with whoever they decide to become intimate with in the future. So I want to reiterate that and put it in there. So it seems like to me that primarily the only thing we have left, if these other things are taken care of, is if you want to let us take another look at who the child primarily lives with. And I'll be glad to take that under advisement, and we will listen to the testimony on that. These other things appear can resolve from the order that you'll draft. Okay. Okay. Thank y'all very much for your patience. Okay. Absolutely. Yeah. Graham versus Graham. Okay, what do we got going on here?
I think it started out with my motion to establish visitation, which is they did a motion for temporary supervised visitation. Got a couple of parties here that have a minor child, that's I think 13 years old. with some visitation. It's not court ordered at this point. But
What does your client want? Just tell me what it is. That's like telling me that when we did that, when mom had surgery, I don't know what they did prior. Just tell me what your client wants. How old is the child? Okay, well, what does your client want?
My client is requesting that we have supervised visitation on every Thursday. There's been a breakdown in their child relationship with Mr. Graham. She became a little bit uncomfortable and fearful. She provided her mother.
Okay, well, I don't want to have to take testimony here. Has this been in front of the commissioner? Okay, well, I want testimony on this. I think that I can see enough separation. It's a long way from going to where you are there to week on, week off. So I want testimony. So y'all get a hold of the commissioner as soon as you can. Your testimony will weigh his findings and tell him that I said that we would request the advance on his docket, okay?
And Judge, if I put it, I don't know why you motion to kind of hold the blood testing report. For both of these parties to be up to actual what included in this hearing, we believe that.
Is there someone here to take it?
We believe that they can go to Jamestown for beer drug testing solutions.
It's still early. What makes you think that either or both the parties?
Ms. Graham feels that there are some heavy substance abuse issues going on that is causing the child to be fearful. There's perhaps some comments made.
How does your client feel about that? Well, I'm sure that. So if he denies it, the hair follicle will be no problem, right? So why don't you, both of you go out in the hall there and call that company and see if they can schedule something this afternoon, go up and do a hair follicle, because they've already missed their days up today and missed work and everything. It's better to do that than try to reschedule it, okay? If there's a problem with scheduling it, come back in and talk to me. Otherwise, we'll refer that, okay?
And Judge, we will also put in the motion if there is any positive results on these hair follicle tests, that any type of invitation.
Well, it will just wait. We won't anticipate there will be. If there is, I will assume that y'all will both, you'll serve notice immediately, and I will allow both of you to do ex parte. Okay, in other words, if there's evidence one way or the other, you feel free to send an ex parte. If neither one of you object to that, I'll enter an order. Okay, either one of you object to that? Okay, thank you very much. Okay, did y'all have any luck back there? We're doing any kind of resolution on that scheduling? You want to come back up? Okay, no luck. Okay. Okay. What did you offer to do here?
I told him, he wants me to supervise with the girls. I told him I did not want to supervise with them. I think I should get my weekends. Like it says in the court papers.
Yeah, well,
And I've got a hair follicle test here saying that I've been playing for so many months, and I got it back yesterday.
yeah. Well, she's got a right to have these visitations. Yeah, so I don't know exactly what I can do about it if she's got a right to have them. You know what I'm saying?
I've tried to propose it to her just for a short period of time. I've never denied.
Well, what do you want to do? I don't want to, what do you want to do?
I just like to, my main concern is the children's safety.
What do you want to do? I know that you're concerned and you don't want to do anything, but give me a,
Houses.
Yeah.
I mean, everything is actually good. 110% happy that she's great and on her way.
yeah,
I've always wished that on mobile.
okay.
But I know.
Well, what do you want to do? I know you convinced me that you have good intentions. What you're hesitant about is overnight right now. Is that correct?
Yes.
Okay. I can understand as much as they've been away for a while. So what I'm going to do is, was it every other weekend? Was it? Yeah, I want not lots of kids not doing a lot right now as far as school activities or what. Or I want you to do every Saturday for like 3 weeks. Every Saturday for 3 weeks. And I want you to have the child, you transport the child somewhere to the police department or somewhere. And I want you to have the child, and for the next 3 weeks, to get the child in the morning, have it the afternoon, okay? And let's just see how that goes. And I want y'all to come back up here on November 17th. These two rule dates are closer together than usual because of the holidays. So I want you to try every Saturday for between now and November 17th, okay? And then on November 17th, hopefully, our hearts will soften, our minds will change. Now, you need to be sensitive to the fact that there's a doubt here whether it's justifiable or not. Because unless there's some pretty strict proof, after that, we're gonna go back to this, what the agreement was, okay? Well, where do you live, sir? Live in Bowling Green. Yeah, and where do you live? Where here? What part of the county? Oakland Heights. You told me that before. I'm sorry. I was just trying to think of some place to meet. I think for 3 weeks, would it be a great imposition for you to drive the girls over here and let her drive them back? Or do what? Do you have anybody that can drive them back? Yeah.
That was part of the original agreement as well. She was supposed to come in on Friday for the weekend.
Yeah.
And I'll come in Sunday. They would actually mom and dad.
Your mom and dad live here?
Yes.
Well, how many weekends are between here? Let's see. I don't think for a while, let's just cut it to about 6 hours then. And then you can transport them both ways for 3 weeks, for 3 weekends, and you can visit your family and that sort of stuff. Because you don't have transportation, I'm not going to deny you access to him, but you also can't expect him to wait over here for 12 or 14 hours or something like that. So y'all, 10 o'clock in the morning is okay? That'd give you time to get up 10 to 4. They give you time to get back over there and still do some stuff in the evening. And you trade here in front of the Justice Center would be a good place. Or once you do that, okay? And let's try to do it. We'll try to get something written on the docket for that. And let's try to take a situation and the fact. And I absolutely don't want either one of you to say anything foul about the other one. I'm not saying that you have, but I don't know whether you're in here when I was talking to other couple that always is a terrible thing to do, and you'll pay for it later because these, okay? Okay.
Thank you.
Okay, now we got the 1:30 docket that's starting at 1:51. I guess this is the call docket here. Roy Anderson versus Medical Center.
They call the response,
They did what?
they call the response, they're ready to move forward.
Okay, we'll pass over that. Southern Tax versus Paul Hunley and others.
Your Honor, I'm Trent Taylor on behalf of Roy Anderson Lumber. I just wanted to show up and put on the record that we did file a response. I don't know if there's anything we need to do other than that, but
You don't
wanted to
need
let
to
you
do
know.
anything. You ready to proceed then?
Yes, Your Honor.
Okay, that'll be fine. Southern Tax Services LLC versus Paul Hunley and others. Okay. Anybody here on that? Okay, we'll strike it. Yeah, dismiss. Anthony Gilbert versus Samantha England. Yes.
Samantha Joe concerning.
Okay, no problem. Okay, you give me a order withdrawn, I'll sign it. Now you may proceed.
Thank you, Your Honor. Your Honor, this is Samantha Joe England, their daughter is 9 years old. When this case.
You want, this is, I'm not here to argue the case. I just want to know whether it's dismissed or not dismissed.
No, we asked that it not be dismissed, that the court enter an order granting.
I'm not going to enter any orders granting anybody anything.
Upon, I think, receiving the notice, of the 1702 notice of the motion for sole care, sole custody file, you can get it from the.
Yeah, well, I'm not going to consider that today since the lawyer just withdrew. In your order, give the other side 20 days. Yeah, 20 days, okay? And then once the 20 days comes back, will 20 days fall before the next rule day? Since this is just a short day here. No, it won't. It won't.
This from the 17th. For the 17th, 21.
Yeah, I don't know whether.
You want me to go ahead?
Well, go ahead and give them 20 days and that they shall appear on the 17th if they have any opposition for granting your order. Maybe you think that would be all right. They shall appear on the 17th if they and express any opposition to your order.
That judge,
He's in jail.
yes,
Well, we'll have to report him to somebody anyway.
should I go ahead and set it for you?
Well, I guess we need to go ahead and appoint him somebody. GAL. So I just think we need to let it ride with appointing GAL and have them to appear, have them interview them and ask them to appear on the 17th.
Yes, sir.
Okay,
Thank you. Your Honor.
okay, yeah, absolutely. National Collegiate Student Loan versus Timothy Spears.
So they got a response. They have not got any service in that case yet. That's what the whole of this.
No service, okay. 7702. I think. Brian Bean versus Lloyd Bean and others.
No responses to file.
Who are the attorneys involved?
Davis and Anthony.
Okay. Okay, we'll dismiss it. Washington Investor Services versus James Grider.
No response.
Okay, dismissed at 7702. Michael Taylor versus Katie Cooper. Okay, dismiss it. Dolores Kersey versus SSNS of Burkesville.
No response.
Dismiss it. First Farmers Bank versus Keith Anderson. Okay, dismiss it. First and Farmers Bank versus Thomas Schmitz. Cumberland County Hospital versus Bobby Riddle. Dismiss it. Capital Bank versus Virginia Burns. Okay. Dismiss. The Medical Center at Bowling Green versus AP Riddle. Yes. Troy Nars and others versus Daniel Nars and others. Yes.
I have not really glanced at that file. I worked with Troy and I really don't know. nothing
Yeah,
happened here.
you're the attorney for the plaintiff. Go ahead, we'll go ahead and I'll come back to that. Shannon Claywell versus Crystal Lou Claywell. Reconcile be dismissed. James Fisher versus Brandon Day Thompson.
On that, Thompson would ask that this man, that's kind of frank, good complaint. When you look at it, it does nothing. So
Okay. Lindmark Financial Services versus Jason Claywell. Dismissed. Cumberland County Hospital versus Steve Elmore.
No response.
Nationwide Agribusiness Insurance Company versus Brand Thompson.
There's no response to file, but an order was appealed in that case. And final order from Court of Appeals was handed over on August 1st.
So leave it on the docket then. Gym Finance versus Freely Cook. Dismissed. Cumberland County Hospital versus Cabarrus. Dismissed. Joseph Curtis Davidson versus LL Davidson.
That respondent is deceased.
Okay. Dismissed. Humphrey versus Day.
I can talk about it. I explained what the notice meant, and I'm not receiving it from them.
What kind of case is it?
Divorce. It's still separated.
Okay, well, just dismiss it. Cumberland County Hospital versus Tom Tomlinson. Dismissed. Cumberland County Hospital versus Paul Willoughby. Dismissed. Gym Finance versus Melinda Hale.
No.
Dismissed. Gym Finance versus Dwayne Uten.
No.
Gym Finance versus Angela Holland. Holland. Okay. Beauty Williams versus Danny James Strong.
That remain on the wrong.
Okay, that'll be fine. Tammy Johnson versus Kenneth Johnson.
That was the divorce case filed here, and then the Clinton County and filed another one. Capital.
Okay, dismissed. Lois Lako versus Michael Reinersman. No, you're still there.
I think about that.
Dismissed. Medical Center at Albany versus Mandy Norris. Okay. Well, where did the respondent live? Demise. Okay, well, this is Anderson versus Anderson. Mullins, it's amazing how many people you caused to reconcile with the cross. I've got it in Mullins versus Rich. Okay, yeah, that's right. That should be, that should stay on the docket. Brian Ballard versus Christopher Obershaim.
Doesn't matter, it's legal, but the paperwork is still being finalized.
Okay, leave it on the docket. Hagan versus Hagan. Dismiss. South Central Bank versus Hubert Vetter. Well, were you involved in it? You're not a record here. Well, I know. Well, I thought you might be kibitzing. I didn't know. Yeah, I don't see you as counsel. I think you got confused with something else. Why don't you come over and look at the file?
We had some sold property. I'm not sure if that was important. Property.
We'll come back to it. Stacy.
This is actually not the one I represented you for in.
Okay.
I had the divorce, that was part of it.
Okay, we'll dismiss that case. Stacy Sue Thrasher versus Tommy Keith Thrasher.
Was there some recent action? EPO or something like that?
I got back together. Those main 14.
Okay, well, I'm just gonna leave this on the docket. Jarek Wilson versus Phil Davidson. Dismiss. Medical Center of Albany versus Allen.
Happening, Robert.
Hello.
When we received the court's notice of life prosecution, we filed motion for retaining off summary judgment.
Okay, you can be heard. Are you represented, Mr. Humphrey, by counsel?
I am now.
Are you represented by counsel? You don't represent yourself. I know who you are. Okay. Okay, you want to move over this way just a little bit, then go ahead and make your motion for summary judgment.
Yes, sir, Your Honor. We filed a motion for summary judgment. Medical services that were rendered to him October 4, 2014, totaling $6,251.50. We received a response from Mr. Humphrey that necessitated us sending out requests for admission to interrogatories. Those requests for admission were not answered. They're going to be 36 are deemed admitted. Further, Your Honor, we filed the affidavit with Kim Madison. Madison is studying the business records of the plaintiff, verifying the balance owed on Mr. Humphrey of $6,251.52 plus 60% interest for our attorney fees and 20% pursuant to the written contract he executed.
What's the total amount?
20% of that.
You got the 6% too. don't you?
Yeah, 6%.
That's okay. What, do you have a defense to this, Mr. Humphrey? You have a defense to this?
Your Honor, the interrogators have been addressed in response.
I didn't understand. Get behind the microphone. I didn't understand. He made requests for admissions for you, and under the rules, you have to admit or deny a request for admission.
Neither admit nor deny.
Well, if you neither admit or deny, then you admit.
I can address each one of these, if you like. These have been addressed in the response. If you like.
What do you, I don't understand what you're saying. I'm not following. Just tell me what you've addressed. Have you denied these things in your response?
I agree with that.
Okay, and based upon what?
Based upon, I do not owe this debt.
Well, why do you not owe the debt?
The statute of limitation has expired, lease.
Well, they filed this case in 2019. What do you think the statute of?
Also filed at the beginning of 2014. 8 years, 29,000 hours. Now, this is the first time I've been in court.
What do you say about the statute of limitations?
Your Honor, we received these services under a written contract in 2014, statute of limitations, 15 years for contract in writing. We filed the suit 5 years later. It's clearly within a 15-year period, Your Honor.
Okay, you got anything else?
Your Honor, I do not, I deny all these dates
Based upon what?
based upon, each one of them is, not true. They had an obligation, Clinton County Medical Center had an obligation to send his bill to the Veterans Affairs Administration. Okay, they failed to do this, John. They did not send the bill to Veterans Affairs. Contacted Veterans Affairs, they contacted you and Adam. Contacted the medical center Albany now. They contacted the administrator, whoever was involved in sending out the bills. They had no record of it at that time. They contacted.
Well, okay, you don't deny receiving the services. You,
I do not deny
what you're saying is that the Veterans Administration would have paid for these services that have been properly billed. Is that what you're saying?
That's one thing.
Well, I mean, that,
Yes.
yes or no? Okay, now, did you have any other insurance and claim? I mean, were they supposed to be the first payor on this thing? They were supposed to pay it first?
Emergency room visit, and, they have to send on emergency room visit, they have to send it directly to the Veterans Administration. And they did not do this.
All this is this one day service?
1 day service.
Yeah.
October the 4th, 2024.
Okay, and what do you,
$1,100 per minute.
it's a bargain. I pay more than that sometimes. You know what they used to say when they asked that surgeon, how much do you charge for the incision? And he said, $100. He said, why did I get this $10,000 bill? And he said, the rest of it's for knowing where to cut. You know what I mean? So, okay. Have you checked in to see if this was properly billed or not?
Yes, sir. In
Okay.
our affidavit, we specifically list that the claim was submitted for Veterans Administration on October the 8th, 2014. On December the 4th, 2014, they received a denial from the Veterans Administration. He did not provide any other information. Through Mr. Humphrey contacted them, they again refiled with Veterans Administration October 21st, 2015, company out of Louisville. They denied that December the 15th, 2015. The hospital completed their obligation by submitting the claim. I'm not sure why VA denied it. Him saying it's an emergency, because I've been doing this about 20 years. It seems like VA will only pay if you get pre-authorization. He signed a contract, he would be responsible for any paid amounts. Hospital rendered the services, didn't answer the request for admissions, and hasn't filed a converting affidavit, and hasn't filed a written response to my motion. It's our position, Your Honor. that we need to issue it.
Do you have any authority to take anything less than the judgment amount?
I do not. He can make an offer, I'll take it. We're going to do the heavy. I'm not, I do not own this debt, and I will not agree with $1.
Well, why do you say you don't owe it? If the Veterans Administration, if they put applications in claims and the Veterans Administration turned it down, you think that alleviates your obligation on the debt?
No, Your Honor, but, they have to submit, they have to send it to the right part of the Veterans Administration in order to get paid.
How you know they didn't do that?
Here's a letter from the administration, Veterans Administration to Clinton County Hospital. Refugee.
What does it say? You can read it if you want to. Have you seen this?
I have not.
Let the attorney.
We asked him to discover.
Well, I just want you to read it, Wait a second. No, you just read it yourself first,
You want to look at it?
Not really, but
Yeah, but
okay, they're not turning, in this letter, they're not turning down the claim. They just sent it to another VA facility. And can you prove that you sent it to another VA facility and they
Yes, sir.
sent it to another VA facility and it got denied?
they refiled the Veterans Administration of Louisville October 21st, 2015. And the VA denied it December 15th.
So here, there are a lot of people that go to VA down in Nashville or Murfreesboro, that area here. And so that's where the claim was initially filed there. And then they write this letter back and saying that you got to file it in Louisville, and you filed it in Louisville.
Yes.
And they denied it too.
Yes, sir.
Your Honor, the original, VA at that time, 2014, was Lexington.
Did you file it in Lexington or Louisville?
The first claim went to Lexington. They denied it. And then they sent it to
This was in Murfreesboro.
The VA Veterans Administration changed mine, from the Community Care Act to Murfreesboro. This, so there was a lot of CD, whatever.
Well, this was the Murfreesboro office that turned it down here. I mean,
all I know, Judge, they submitted it twice. Yeah, they denied it twice. He signed it.
what was the denial the second time? Do you have a copy
I
of
don't
that?
have a copy of it. Just going by what I read and stated on her application.
None of all this will be today. That is the first time I've been for 8 years. They seem to file these.
Well, if you got another document you want me to look at, I'll look at it. This one was filed on 9/13/20. The letter was rather received on 9/13/20. So they refiled it somewhere after that.
And in July of 2021, the hospital spoke with VA. I believe Mr. Humphries was on that phone call, advised him that he would have to appeal the denial of VA, which is kind of why we held off doing it. Just fine to get it resolved.
Did you appeal that?
Your Honor,
Did you appeal it?
no,
Okay. Okay. Well, I'm going to enter, I'm going to enter judgment on the summary judgment and what we have to do to get some settlement authority to Mr. Humphrey. If he changes his mind, can you give him a card?
Oh, well, you should have my information. Give the motion attention.
Nobody keeps cards anymore, so.
My name's Charles. Well, the best thing for him to do, Your Honor, would be to call us with them all. Yeah, how we present it to the hospital, they're very good.
Well, now, let me ask you about this amount that's charged. Was this their rack amount? If they had been just billing this, the VA, if they'd reimbursed them, wouldn't have reimbursed for that amount, would they?
I don't know.
Well, I mean, I don't know of an insurance company that pays for the
Seems like all the
amount
insurance companies pay and make contractual adjustments.
for less. I would ask you, I mean, we're dealing with a veteran here, and I appreciate your service. Will you just take it upon yourself to find out how much the VA would have reimbursed him for? And if you'll tell Mr. Humphrey that, Mr. Humphrey, you can make your decision on whether you want to offer him that or not, okay? Okay, thank you very much for thank you for your patience, okay?
Yes, sir.
Okay, thank you. Okay,
Thank you.
okay.
Judge, are you reading?
I'm granting summary judgment.
I'll send you a letter.
Okay,
Thank you, Your Honor.
yeah, thank y'all. Joseph Chad Bryant versus Alicia Rochelle Bryant. No response, dismissed. Cumberland County Hospital versus Aaron. Respondent is deceased. Okay, dismissed. Mid-South Capital Partners versus Ruby Burton. Okay. First and Farmers versus Tammy Stivers. Mr. Judd, you were involved in. Yeah. Okay. Oh, it's Ken was involved. Janet Strout versus David Strout. Dismissed. Caitlin Higginbotham versus Tyler Young. What, are you involved in this? What's going on here?
We started this case with a notice of appeal on time.
David Cross was involved in it too. So y'all want to stay on the docket?
I don't want to do it. It's important.
Okay. Okay, we'll leave it on, okay? Yeah. Casey Anderson and others versus Sarah Hayes.
There's not a responsible call, but the plaintiff called and then he's gonna hire an attorney.
Okay, we'll leave it on the docket. Mid-South Capital Partners versus Edwin Anderson.
No.
First and Farmers National Bank versus Tina Adams. Paul Absent versus Clifford Riddle. Now, Mr. Absent is deceased. This was just filed in 20. Who did the Hall Absent estate? I'll leave that on there. That I don't know. Do what? Yeah, but who was the plaintiff in this? Who was the plaintiff's attorney in this case?
One thing to file is a complaint where she was going to start.
Well, let's leave that on the docket since the death is fresh. And would you take that? And Ms. Cap's handling this, they ask her about that. First Financial Bank versus Catherine Kyle. Okay. Shelley Daniels versus Donnie Daniels.
There's a swap file this morning.
Okay.
They are, all I need is their big classes.
Okay, there's on the docket. Southern Tax Partners LLC versus Jennifer Park and others. American Car Mart versus Josh Polk.
They file a motion to remain on the docket.
Okay, leave it on the docket then. Bernice, Michelle Stearns versus Jamie Garrett Stearns. Okay, are these some of the parties here? Yeah, have y'all reconciled with each other? Or? Do what? Okay. What's been the holdup? Well, hope springs eternal in these marital sort of things. And what kind of disagreement y'all have on the settlement? Is there any? Why don't you go back there and talk to him just for a second and see if you can finalize this thing for him? Okay. Anderson versus Anderson. They dismissed. Cash versus Firely. They dismissed. Family Tradition LLC versus John McKinney.
There was a swap file and they set a motion next month for a trial.
Okay, leave it on the docket. One Main Financial Group versus Brian Kelsey.
You know, I represent district and they're asking remain on the docket.
Okay,
Motion.
okay, we'll do that. Cumberland County EMS and others versus Wanda Brown and others. Okay. Dismiss. Dakota Allen Anderson versus Angela L. Anderson. Okay. It's West Bend Mutual Insurance Company versus Fletcher Excavation.
They filed a response.
Okay, leave it on the docket. Josh Muse versus Brittany Muse.
Those parties have it.
Okay. Bobby Joe Bishop versus Aaron Renee Bishop. Okay. Okay. Navy caps versus Navy caps.
There's a motion for summary judgment involved.
Everybody noticed it. Okay. Leave it on the document. Okay. Heaton, Sabrina Gill, Heaton versus Jory Elliott. Okay. What kind of case is that? Okay. Juliana Maria Sams versus Christopher Lee Sams. Okay, dismiss. Ferguson Farmer versus James Garman. Okay, dismissed. Honeyman, Julie Erica Honeyman versus Corey Allen Honeyman. Okay, dismissed. Okay. Does that complete the docket?
In 2013, both Matthew Cook and I submitted proposed findings to the solicitor, and that was for a purpose. I would get it on.
We'll leave that on the docket and notify the commissioner, see if any action can take on there. There years, but must be going well. There's a thing right there. Okay, is there any other docket? What do you have? You want to come up?
The child support office renoticed that for December.
I haven't got it.
Well, that was a county attorney's child support, and they renoticed everything.
That's on doc.
Only thing they had on docket, so they.
Let me make sure it's December. Okay. That's actually next month, 17th, that one, November 17th.
November 17th. Yeah, no problem. Okay, that concludes the Cumberland Circuit Court.
Oh, Storm. Signature back.
Oh, yeah. Well, let's just hold it, go off the record just for a second, and we'll see if they come out.
Grade school, he got a meeting with a kid. About another kid today in the same school. He had a distraction.
It's actually okay.
BJ went and got him. The school nurse had been called away to an emergency at the high school, so they didn't come away and check him out or anything. Just to be safe, BJ went to Lori. No, he said he's acting fine, he's just keeping an eye on him. He had dropped his jacket in the hallway, walking, and did gotta pick it up, and another kid tripped over him. He was right, and people out. Fractured his skull. The age of the same.
Okay, let's go back on the record.
She's coming.
So,
Wait a second, she got to turn you back on. Oh, great, go ahead.
okay, so we think this would be for us to keep the divorce, and I can draft up an agreement, we sign it.
Yeah, when you want to get them on the record, to say what their position's going to be, or,
We can do that, sure, right? Sure.
hey, tell us, both of y'all listen very carefully what this attorney says. Go ahead.
Okay, so my understanding is that there's no real property, I don't have any car to worry about, vehicle to worry about. I don't think that either has any debt that's in either of their names, but if they do, they're both agreeable to any debt that's in their own name, they would be solely responsible for. There's no, each one of them does have personal items, personal property, but they're in agreement that any personal property in her possession would remain with her, any personal property in his possession.
Are there any medical bills unpaid? Do you have a medical card? Yeah, okay. Okay, if you'll draft it up and get them, are there no children involved?
No children involved, no.
Okay.
This part of the children.
Okay, well, just send it to me and, have both of y'all sign it, send it to me with the documents. He knows how to do it. We'll get it over with, okay?
Okay, thank you.
Thank y'all for your patience. Okay, let's go off the doc.
He's not withdrawn, correct?
No, he's going to do it.